to stand when called up so that they may be acknowledged in the Senate tradition. The Honorable Abdul Hakim Were Shehe, Member of the County Assembly. Honorable Makka Maimuna, MCA. Honorable Mahmoud Gabo, MCA. Honorable Masha Boru, MCA. Honorable Hamid Babusa, MCA. Honorable Ismail Kadobo, MCA. Mr. Timna Komora, Legal Counsel. Mr. Bashir Nadir, Clerk Assistant. Mr. Hussein Hirsi, Sergeant at Arms. Mr. Jeremiah Barisa, an aide. And Ms. Brenda Komora, Hansard Officer. On behalf of the Senate and on my own behalf, I extend a warm welcome to the delegation and wish them all the best for the remainder of their visit. I also have another communication. Honorable Senators, I would like to acknowledge the presence in the Speaker's Gallery this afternoon, a visiting delegation from Kisii University. The delegation consists of 10 students from the Faculty of Law who are visiting the Senate to gain first-hand experience in the lawmaking process. Honorable Senators, on behalf of the Senate and my own behalf, I welcome the delegation and wish them a fruitful visit. I will call upon the Senator for Kisii County to, under 1 minute, extend a warm welcome to the delegation from Kisii University and the Majority Leader to extend a word of welcome on behalf of the delegation from Tana River County, in that particular order. Proceed, Senator Onyonka.
Thank you, Mr. Speaker, for giving me the opportunity to welcome this delegation of young Kenyans who happen to come from Kisii University in Kisii County. I wanted to inform you that this building is what is called the gallery. You can see where the Speaker sits, and you can see where all of us sit around this place. I hope that you will be watching, observing, and listening to the procedures of the House. Information I have is that 1 or 2 of you, 3 of you are actually lawyers, and most probably you might end up getting a job in this House as a clerk, or become members of the Senate, or become members of Parliament. I welcome you, and once you're done, you could ask me, I take you to the coffee shop where we drink our coffee, and I will gladly be happy to receive you after you're done. Thank you, Mr. Speaker, for allowing these brilliant minds to come and express and see for themselves what this House stands for. Thank you, sir.
Majority Leader.
Thank you. Mr. Speaker, I'd be remiss if I don't recognize the comrades from Kisii University. So I join the Senator for Kisii in welcoming them to this August House. I hope they will drink to their fill and enjoy all that they came to find out when they set out from Kisii to come to this House. Second and most importantly, equally importantly rather, Mr. Speaker, is to appreciate this delegation from Tana River County, the members of a county assembly. The collaboration between county assemblies and the Senate, Mr. Speaker, is at the heart of success of devolution. And each time we have a delegation from any of our 47 county assemblies coming to the Senate to learn a thing or two, Mr. Speaker, I feel immensely proud because I know, Mr. Speaker, that by the time they leave this House, they have learned a lot that they can implement in their county assembly so that we enshrine and celebrate devolution. Their senator is not here, Mr. Speaker, but as they do know, once they sent Senator Danson Mungatana to come here, this House also elected him to be a member of the Pan-African Parliament. So he juggles his duties between here in Nairobi and South Africa, where that continental parliament sits. One last thing, Mr. Speaker, about Tana River. This is a very special county to those of us that are members of the UDA party. This county gave us the leading anthem in our campaign in 2022. There's a duo that sang a very catchy song called Ruto Tosha, Mr. Speaker. If these members of the county assembly know the singers, please ask them that the majority leader invited them to this house. The last time I saw them, they were complaining, saying that after campaigns, nobody has reached out to them. So I hope if any of the county assemblies members that are here knows the duo that sang that song, tell them they have an open invitation to come to this house and meet me. I thank you, Mr. Speaker.
Next order.
Order number 3, messages. Order number 4, petitions.
Now, Honorable Senators, pursuant to Standing Order 232(1)B, I hereby present a petition that has been submitted by Mr. Fred Saweja and other petitioners regarding the winding up and liquidation of Technical University of Kenya Staff Retirement Benefit Scheme. As you are aware, Article 1191 of the Constitution states, and I quote, "Every person has a right to petition Parliament to consider any matter within its authority, including to enact, amend, or repeal any legislation." The salient issues raised in the petition are as follows. 1, that the Retirement Benefits Authority, RBA, which is mandated to regulate the pensions subsector in Kenya, petitioned the Milimani High Court in 2017 in the matter of insolvency of the Technical University of Kenya Staff Retirement Benefit Scheme, case number HC IP/14/2017, to protect the scheme's members from losing their retirement savings. That on the 5th of July 2024, the RBA obtained orders from the Milimani High Court to wind up and liquidate the pension scheme, which resulted in approximately 2,000 scheme members being at risk of losing the lifelong savings accrued from years of hard work, potentially downgrading them to a life of poverty in their later years. That the scheme deducted members' contributions, however, these amounts were not remitted to the fund manager. That some officials at the university, through acts of commission or omission, failed to account for and remit the funds, leading to uncertainty and distress among staff. Further, a number of officers have left service, and the ones in the office may not be familiar with the case. That as a result, some members have lost their lives, while others have suffered illness due to psychological stress caused by this situation. That the scheme owes its members billions of shillings that remain unaccounted for, supporting the claim that it may have been undertaking fraudulent operations. That the Technical University has failed to protect its members, stakeholders, and assets due to lack of efficient and effective oversight of affairs of the university, and that the members of the scheme have made efforts to address this matter with the university management, the University Council chairperson, the RBA, and the Minister of Education, all of which have been unsuccessful. That the petitioners therefore pray that the Senate investigate this matter with a view to do the following. 1, ensure that the assets of the scheme and contributions owed to members are safeguarded, including the transfer of members to other schemes where possible to ensure the continuation of the pension contributions. 2, ensure that the circumstances that led to the poor financial performance of the scheme and its subsequent insolvency are addressed, and that the responsible persons are held accountable. And 3, formulating legislative interventions aimed at preventing similar occurrences in retirement schemes in the country. Now, Honorable Senators, pursuant to Standing Order 238(1), I commit the petition to the Standing Committee on Labor and Social Welfare for consideration. And in terms of Standing Order 238(2), the committee is required in not more than 60 calendar days from the time of reading the prayer, which is today, to table its report in the Senate for consideration. The Senate shall thereafter consider the report of the committee. I thank you. Next order.
Order number 5, papers.
The Senate Majority Leader.
Mr. Speaker, sir, I beg to lay the following papers on the table of the Senate today, Wednesday, the 13th of November, 2024. This is a Sustainable Waste Management Extended Producer Responsibility, Legal Notice number 176 of 2024. The Environmental Management and Coordination Water Quality Regulations, Legal Notice number 177 of 2024. The Environmental Management and Coordination Waste Management Regulations, Legal Notice number 178 of 2024. The Environmental Management and Coordination Sand Harvesting Regulations, Legal Notice number 179 of 2024. The Environmental Management and Coordination Air Quality Regulations, Legal Notice number 180 of 2024. The Environmental Management and Coordination, Management and Control Plastic Packaging Materials Regulations, Legal Notice number 181 of 2024. The Environmental Management and Coordination, Management of Toxic and Hazardous Chemicals Materials Regulations, Legal Notice number 182 of 2024. Mr. Speaker, I beg to lay.
Next order.
Order number 6, notices of motion.
Next order.
Order number 7, questions and statements.
Statements pursuant to Standing Order 53-1. Honorable Senator Esther Okenyuri.
Thank you, Mr. Speaker. Request for a statement on the increase in cases of femicide and arrest and abductions of the youth in Kenya. Mr. Speaker, sir, I rise pursuant to Standing Order 53-1 to request a statement from the Standing Committee on National Security, Defense and Foreign Relations regarding the alarming rise in incidences of femicide and troubling trend of arbitrary arrests and abductions of youth in the country. Mr. Speaker, sir, in the last 90 days alone, the country has witnessed the tragic deaths of 97 women due to violence. This serious trend of femicide has reached crisis levels, devastating families and communities and undermining our societal fabric, our women, and hold perpetrators accountable. Moreover, there are alarming reports of youth abductions which are equally distressing, as many young people disappear under mysterious circumstances, often resulting in tragic outcomes. This is not just a crime against individuals, but an assault on our nation's future. Mr. Speaker, sir, noting the severity of the above incidences, I request the committee to, 1, furnish the Senate with a report on the immediate steps taken to thoroughly investigate the incidences of femicide and the alleged abductions of youth, and 2, outline the comprehensive strategies that have been developed to address the root causes of such violence and insecurity affecting our women and youth, and to ensure non-recurrence of the same. Thank you.
Senator for Kisumu County, Professor Tom Ojenda. That statement is dropped. Honorable Senator Chimera Raphael.
Asante, Bwana Spika. Angu ni ombi la kauli kuhusu uendeshaji wa kampuni ya Base Iron Limited ama ukipenda Base Titanium Limited katika mradi wa madini ya Kwale Mineral Sands, eneo la Msambweni, kaunti ya Kwale. Mheshimiwa Spika, nimesimama kwa mujibu wa kanuni ya kudumu ya 53(1) kuomba kauli kutoka kwa kamati ya kudumu ya ardhi, mazingira na mali asili kuhusu uendeshaji wa kampuni ya Base Titanium Limited katika mradi wa madini ya Kwale Mineral Sands ulio eneo la Maumba, eneo bunge la Msambweni, kaunti ya Kwale. Katika kauli hiyo, Bwana Spika, kamati inapaswa: 1, kutoa nakala za awali za mkataba wa ununuzi wa mradi wa Kwale Mineral Sands ulionunuliwa na kampuni ya Base Iron Limited mnamo Agosti mwaka wa 2010 kwa ajili ya uchimbaji wa madini ya titanium, pamoja na nakala za mikataba yoyote ya ziada iliyofuata inayohusiana na mradi huo. La pili, Bwana Spika, kuelezea jumla ya fedha ambazo kampuni ya Base Titanium Limited imetoa hadi sasa kwa jamii ya eneo husika kwa mujibu wa kifungu cha 183 cha sheria ya madini ya mwaka 2016 kwa ajili ya shughuli za wajibikaji kwa jamii, na kuelezea iwapo kuna kiasi chochote cha fedha ambacho kijatolewa kufikia sasa. Na mwisho, Bwana Spika, kufichua maelezo ya mkataba wa maendeleo ya jamii kati ya kampuni ya Base Titanium Limited na jamii ya eneo la Maumba Msambweni, pamoja na kutoa taarifa ya hali ya utekelezaji wa mkataba huo na orodha ya miradi yote iliyotekelezwa na Base Titanium Limited kulingana na mkataba. Asante Bwana Spika.
The Senator for Nandi. You may proceed, Senator. Yeah.
Mr. Speaker, thank you, and I hope all members will listen to this very critical statement. The Senate statement of an issue of general topical concern on the contempt of Senate committee invitations by county governors. Mr. Speaker, sir, I rise pursuant to Standing Order 52.1 to make a statement on the issue of general topical concern and national importance, namely contempt of Senate committees invitation by county governors. Mr. Speaker, sir, in carrying out our oversight mandates over county governments, committees of the Senate issue invitations to county executive governors to deliberate and interrogate matters within the mandates of respective committees. Mr. Speaker, sir, a trend has developed where some governors have consistently failed to honor invitations by committees, and in so doing, requests for postponement of meetings without justifiable reasons. The frequent request for postponement of meetings has greatly derailed the effective discharge of committees' mandates and thus negatively impacting on the oversight mandate of the Senate. Mr. Speaker, sir, notably, the Governor of Kisii, His Excellency Simba Arati, has on 3 invitations in the current calendar year failed to appear before the Senate County Public Accounts Committee on the grounds of traveling outside the country without the reason as to why he is traveling outside the country, just to avoid appearing. So, Speaker, sir, further, the Governor of Isiolo, His Excellency Guyo, of Isiolo County, has failed to appear to various committees, specifically the devolution committees and others, but only send written response without communication on his non-appearance, and even issuing in-person to threats to some of the senators. Mr. Speaker, sir, the prevalent disobedience of committee invitations, and of course, Mr. Speaker, these governors should be ashamed of what they are doing. The prevalent disobedience of committee invitations amounts to the contempt of the Senate authority, which enjoys the quasi-judicial mechanism of status of the High Court, and even checked, will negatively erode the confidence bestowed on the House by the great people of Kenya. Mr. Speaker, sir, various committees have applied Section 18 and 19 of the Parliamentary Powers and Privileges Act to compel witnesses to appear. The penalties imposed by the Act are not deterrent enough. Mr. Speaker, sir, in conclusion, in order to realize optimal cooperation by the county entities, the Senate may consider amendments to Article 125 of the Constitution of Kenya and to the Parliamentary Powers and Privileges Act to provide for higher penalties for violation of the Act. Further, legislative interventions be developed, Mr. Speaker, to empower the Senate to be conferred with original jurisdiction to initiate impeachment of a county governor for gross violation of the law and failure to comply with accountability frameworks provided under the law. Mr. Speaker, I am issuing this statement on behalf of the Senate Public Accounts Committee as the powerful vice chairperson. Myself and the chair, we enjoy a cordial working relationship, and like other institutions, Mr. Speaker. With those very many remarks, I thank you.
Thank you, Mr. Speaker. And I want to comment about the statement raised by Senator S.C. Okenyuri on abductions. Mr. Speaker, this is a matter that should concern every Kenyan of goodwill and every Kenyan that wants to see a country that have a developing democracy. Mr. Speaker, anybody given power in this country must exercise it in the right way and for the benefit of Kenyans. Mr. Speaker, police officers are trained to be able to arrest anybody in broad daylight, Mr. Speaker, and of course prefer charges against them if need be. Mr. Speaker,
Mr. Speaker, I'm rising under standing order number 1. Mr. Speaker, you've ruled that this session will last for 15 minutes. But I keenly noted that you did not rule what a senator's time could look like. And given that a number of us would also want to chime in, would you please perhaps give a guidance, perhaps it will take 2 minutes or so? Thank you.
Thank you, Mr. Speaker, and I may want to also to let Senator Eddy know that the Speaker knows his job, just in case. So, Mr. Speaker was saying that it's a matter of concern, these abductions, Mr. Speaker, and hooded police officers arresting people. This is something that we should not allow in this country, and Mr. Speaker. The statement by Senator Cherargei, Mr. Speaker, also cannot go, of course, uncommented about, Mr. Speaker, because we have the right to oversight our county government. Any governor that does not honor the invitations by the Senate must be called to order, Mr. Speaker. And so I support in total the statement and the plan by Senator Cherargei to see to it that we rein governors, because, Mr. Speaker, as was said by the former majority leader, Adan Duale, Mr. Speaker, pesa wanazokuwa nazo si za mama zao. Thank you very much, Mr. Speaker.
Thank you. Thank you. Thank you very much, Mr. Speaker. I would like to just support Honorable Cherargei as my Vice Chair in the Committee of CPAC. Mr. Speaker, this matter is not simplistic. We have been sitting in the CPAC committee, and indeed, without anybody interpreting and thinking that our agenda is basically to make sure that we disagree or we make noise at the governors whom we disagree with. That's not the issue here, Speaker. There are some governors, we've invited them, they have come on time, they send their documents on time. The standing orders require that some of the documents are delivered to us at least 14 days before the period that we meet the governor. And some of them have come with their officers, and we have been satisfied with some of the good work some of them are doing. And yet in reality, Mr. Speaker, where we are now is you find that our responsibility as the team that is oversighting the county governments and even the national government, if we allow this precedent to take place, if we allow governors to unilaterally make a decision that they are going to come up with some flimsy excuse to come and justify why they cannot come, and we interrogate their books so that publicly their voters and their citizens can know whether they've been doing a good job or not, is unconscionable and unacceptable. I would like to thank Honorable Cherargei for standing firm. And indeed, Mr. Speaker, I don't take some of these issues lightly. We know that Honorable Dulo, who's been the senator for Isiolo County, has received death threats. It's on video. We have seen where many of these governors who have got basically impunity telling us how they feel there's nothing we can do. And I will be, in fact, one of the people who's going to support the amendments which are going to come. I think let us be honest and ask ourselves, what happens to a governor who deliberately decides they're not coming? Or what happens to a governor who, once he's been summoned and he pays a fine of 500,000 shillings 10 times? What then do you do with that? How do you create deterrence? And Mr. Speaker, I hope that all the governors will listen to what we are saying. We are user-friendly. We are not their enemies. We are not saying they have done anything wrong. We just want the facts and the reality to be put on the table so that the public can build confidence in our capacities as leaders and as the people who are oversighting both the government and the county governments. Thank you, Mr. Speaker.
Asante Bwana Spika kwa kuweza kunipa fursa hii na mimi niweze kutoa changizo zangu kwenye statement ambazo zimeitishwa. Kwanza ningependa kuchangia statement ya dadangu Senator USA Kenyans kuhusu abductions ambazo zinaendelea. Ningependa kuzungumza na sisi viongozi na hata wananchi kwa jumla. Pindi anapopotea mwananchi, tusiwe na haraka ya kuhukumu kwamba ni serikali imemchukua mtu kama yule kuenda kumfanyia labda mambo mabaya. Kwa sababu zana ile inafanya wale wahusika ambao wanapaswa kufanya utafiti kwa kuda alikopelekwa yule aliyekuwa abducted kuwa ngumu, kwa sababu tayari tumeweza kunyosha kidole cha lawama katika taasisi fulani. Pili, niweze kuchangia pia katika statement ya ndugu yangu Cherad Gay, Bwana Speaker. Mimi kama mwanakamati wa kamati ya CPIC hapa Seneti, tumekuwa tukiita magavana mara moja na mara mbili. Na kama tulivyozoeza kuzungumza awali, kwamba tunapowaita magavana kama hawa kuwauliza maswali, sio kwa nia mbaya ama kwa jambo baya. Ni kuweza kuweka uwazi katika yale mamlaka ambao tumepewa na bunge hili la Seneti. Lakini tunapoona kwamba kama mfano wa seneta wa Isiolo, seneta wa Kisii, juzi pia nimeona magavana ambao tumekuwa tukiwaita katika kamati yetu ya Labor, kamati yetu ya CPIC, wanakataa na wanaenda katika vyombo vya social media kusema kwamba hatutakuja kwa sababu kuna atiati, kuna nini, kuna siasa. Sisi hatuko hapa kisiasa, tuko na majukumu kama maseneta wa taifa la Kenya kuweza kuona kwamba zile pesa tunatetea kuenda katika magatuzi yetu 47 zinatumika kwa usawa, na yale mapendekezo tunawapa wanaenda kuyafanyia kazi na sio kwa sababu nyingine. Bwana Speaker, ningependa kuambia viongozi wa kisiasa katika taifa letu la Kenya ya kwamba watu wanapotekwa nyara, tuweni makini kuweza kunyosha vidole vya lawama, kwa sababu tayari tunapeana mwelekeo ambao labda siwo, kwa sababu haiwezekani serikali iendelee kupoteza wananchi wake wakati yeye ndiyo ako na mamlaka ya kuwatunza maisha yao. Asante Bwana Speaker.
Thank you, Honorable Speaker. Honorable Speaker, I rise to support the statement by Senator USA Kenyans. And Honorable Speaker, on humanitarian grounds, Honorable Speaker, all of us must be concerned about the recent killings, especially of young girls. But Honorable Speaker, the most amazing thing is that most of these deaths seem to be executed by people that are known to these victims. And so, Honorable Speaker, we want to call upon everybody, family members, let us be on the lookout. Let us discuss with our young sisters and young girls on how to go about some relationships that they have. And Honorable Speaker, also to share with everybody that even when people disagree, there's always a way in which we can sort out most of this disagreement. Honorable Speaker, secondly, I want to support the statement by the Senator of Nandi, and to say, Honorable Speaker, that as Houses of Parliament, we have a duty to execute. And the governors must know that just as they were elected by the people to lead those counties, the senators here are equally elected to oversight them, to represent the Kenyans all over the country. And so, Honorable Speaker, it cannot be a choice of a governor to choose when to come to a committee or to choose when to come, because they do not have that choice. Once they swore to serve their people, once they swore to protect the constitution of this country, they must live up to the expectations of the same constitution. They are not doing anybody a favor by coming to the Senate. They are not doing anybody a favor by coming to the committee. And Honorable Speaker, these are constitutional offices. And if people feel that they can operate at their own whims, they have the option of stepping aside so that we get leaders that can support and can work for the people as per their expectation. Honorable Speaker, the Senate must stamp its feet. The governors have no option. They must come and appear in the committees, because even the senators are just doing their work, and we must represent the people that we represent here. We must oversight, and the governors have no choice. Honorable Speaker, I support.
Thank you, Honorable Speaker. I want to comment on two statements, one by Cherargei, Honorable Speaker. Honorable Speaker, after election, normally, generally, the senators, MCAs, and National Assembly, I think they go through an induction. I believe it looks like our governors also might, in a way, require an induction, either by Intergovernmental Technical Committee or Minister of Devolution, so that they are also they get to know that when they are invited to the Senate or to the committees, they need to honor. It's not a favor for them to come to Senate. Our job is to do oversight, representation, and legislation, Honorable Speaker. So they need to work very closely, because senators are champions of devolution, and the resources they get, it passes through this House, Honorable Speaker, because we are surprised. Some of them give glimpse reasons that they are away, they are engaged in a prior engagement. They need to know when they are invited to Senate, it is priority number one, Honorable Speaker, not the other engagements, because they need to work for the people, and we need to follow up what they are doing as our mandate, Honorable Speaker. In fact, in CIVIC and even other committees, we get some funny reasons, you know, that they don't. It's like what we got this morning, Honorable Speaker, by one of the CSs, the CS in charge of KWS, Honorable Speaker, that she has gone to witness putting devices in a rhino instead of coming to the House until Senate adjourned early in the morning because of some just flimsy reason. I mean, that is something you can send the Director General for KWS or even the PS instead of wasting Senate's time, Honorable Speaker. Honorable Speaker, it is unfortunate that we are losing our young girls through femicide, Honorable Speaker. As Senator Beatrice Okwala said, some of these could be relationships related, others could be some criminals who are after organs or whatever, Honorable Speaker. We need the new Inspector General of Police, Honorable Speaker, to stamp his foot and authority and ensure those who are doing abductions and killing our girls, they need to put them, Honorable Speaker, to bring them to book, Honorable Speaker. I don't know why they take a lot of time and they say they don't know. How can you have intelligence and have resources? Because Minister of Interior is the most highly resourced Minister, Honorable Speaker. They need to use the proper intelligence. Let them use also technology. We have technology that can assist in terms of ensuring that those who are doing these activities are branded, Honorable Speaker. I support.
Mr. Speaker, thank you very much for this opportunity. And I wish to thank my Vice Chair of PAC on his statement. Mr. Speaker, I remember you saying that this is a time for action, it's not time for lamenting. We have actually experienced that some of the governors are taking the cue of Governor for Isiolo in various committees. And I think this has to stop. Mr. Speaker, I've been around for some time, and I have never seen a governor who is taking a committee of the House to court just because of appearance. It has never happened. Number two, there are summonses that has been given to the governor of Isiolo, and I see there is actually one from Labour Committee where they have instructed IG to arrest him and bring him before the committee of the House. I hope that is going to work. And if that doesn't work, then we have proved the governor for Isiolo right, because he's been going around saying there is nothing Senate will do to him. Even if he fails to appear many times, Senate will do nothing to him. Mr. Speaker, that is impunity of the highest order. I have even been discussed at the county, at the Council of Governors, that I'm rogue. Let me be rogue because of doing my work. Mr. Speaker, before we went on recess, I read a statement on the floor of this House. And Mr. Speaker, let me be open. 10 members of staff from county government of Isiolo sat in the boardroom of the governor. They discussed on how to eliminate me. I have a clip and I have photos of those members of staff. And he has audacity to tell members of public and the newspaper that I'm lying. He's been going around saying he knows everybody in the government, DCI, EACC, and nobody is going to do anything to him. Mr. Speaker, this is a raw governor who does nothing. Mr. Speaker, he operates from Nairobi. He's never in Isiolo. And secondly, he has no respect at all for the House of Senate. Mr. Speaker, we discussed this matter yesterday. County assembly members are in the pocket of the governors. We must have a solution to this problem where Senate can take action on those rogue governors. I thank you.
Mheshimiwa Spika, nashukuru sana kunipa nafasi hii. Wakenya wanatazama kwa makini sana yale yanayojiri hapa katika jumba la Senate. Jana katika vyombo vya habari, Mheshimiwa Spika, tumeona viongozi shupavu wa Senate wakitetea gatuzi zetu ili fedha zisije chini ya bilioni 400. Mheshimiwa Spika, haiwezekani tuwalishe mamba watule sisi. Haiwezekani. Haiwezekani tukeshe kila uchao tukitetea wananchi wa kaunti zetu wapate pesa, ili hali kuna viongozi ambao wanadhana kana kwamba sisi ni kama wasukuma rukwama kwa niaba ya watu wetu. Hatutakubali. Mheshimiwa Spika, iwapo Senator Dulo ana hakika kwamba sekta ya afya imedorora, wengine hapa wanatuambia sekta ya kilimo imedorora, wengine wanatueleza sekta ya elimu katika kaunti imedorora, na tukiita viongozi hawa katika vyumba vyetu vya kamati hawaji, wanapiga kifua na kubwata maneno yasiyoeleweka. Mheshimiwa Spika, wakati umefika tuonane jicho kwa jicho. Almashauri kule mashinani tunasema mundu kumundu. Mheshimiwa Spika, Mheshimiwa Spika, haitawezekana Wakenya ambao kila siku wanadai ushuru unapanda, lakini ushuru huu unaporudi katika mikono ya magavana, wao ni kufurahia. Tunapowaita wanasema wako katika safari za ng'ambo. Mheshimiwa, ng'ambo mimi najua ni Zayuni peke yake, na iwapo wanataka kwenda Zayuni tuonane baadaye, lakini iwapo wanahudumia Wakenya ni lazima na ni lazima waje wabebe misalaba yao na kwa vinywa vyao wakiri dhambi zao, na iwapo wana makosa, Mheshimiwa Spika, lazima wabebwe hobela wawekwe korokoroni. Na mimi nataka kuambia magavana popote walipo, na kama hawanioni wataambiwa kwamba tulisema tunafungua ukurasa upya wa ugatuzi Kenya hii. Unapopewa pesa nyingi, uwajibikaji ni wa hali ya juu. Tutawaandama kushoto, kulia, kwenye handaki, mlimani, kote tutafika ili ugatuzi. Na sisi Mheshimiwa ni wasanii wa nyimbo za mafoka, almashauri tunasema tutaanguka na wao. Mheshimiwa Spika, na kisha kuanguka nao, tutafinish kumalo. Hiyo ndio lugha vijana mashinani wanaelewa, kwamba lazima ugatuzi ufanye kazi na lazima wawajibike. Asante Mheshimiwa Spika, ndugu yangu wa Migori, lazima tufanye kazi. Thank you Mheshimiwa Spika.
Thank you, Mr. Speaker. Mr. Speaker, I want to associate myself with the statement made by Senator Okenyuri on this matter, Mr. Speaker, of abductions and killings in the country. Mr. Speaker, a time has come, and now is, that Kenyans must begin to demand real justice. Justice for the people that are being killed and justice for people that are being abducted. And Mr. Speaker, that demand goes to the government of the day. Mr. Speaker, the number of killings happening in this country must actually begin to scare everyone. And if the intention of the killers, the Speaker, was to scare this nation, then this nation is getting scared. Hardly a day passes, Mr. Speaker, before we hear reports of people killed, bodies recovered, people disappearing. Mr. Speaker, something must be done. On the matter of governance, as espoused by the Senator Fonandi, Mr. Speaker, we must admit, all of us, that this country is actually facing a crisis of governance. That 2 years into a government, Mr. Speaker, we have so many impeachment proceedings against governors and their deputies. In fact, in the history of this country and in the history of this region, 2 years into governance, into a government, a deputy president has been impeached. Mr. Speaker, there is a problem. That we must admit, that there is a problem, there is a crisis of governance. Mr. Speaker, I say this because governors have become so emboldened that actually they think that they own counties, and that what they say is law. Mr. Speaker, I think I am one person who likes using the issue of impeachment very sparingly, but on this one, and to save the image of this House, the Speaker, lessons must be sent to governors that we mean business. For a governor to, as Senator Dula is saying, to bring together leaders in his cabinet to plot the assassination of a senator who is just doing what she is elected to do. The Speaker, shame on that governor. I mean, we should never allow these things to happen, the Speaker. And I will stand with my colleagues to demand that the governor for Isiolo be brought here in this House. The Speaker. Thank you, Mr. Speaker. That the governor of Isiolo be brought before this House, Mr. Speaker. Let him now, if this is what he does, if this is how best he deals with these things, let him now go and organize the assassination of the 67 senators of the Republic of Kenya. Mr. Speaker, it cannot be that when senators ask questions on how money is being used, they become enemies of governors. Mr. Speaker, it is weird. I mean, we have been in this House before, Mr. Speaker. Mr. Speaker, you have been a governor. You've been asked questions about how you have used resources of the county government of Kilifi. I've never heard anybody saying that you have threatened them for being asked questions. Mr. Speaker, these governors have become semi-gods. You know, they have elevated themselves to the level of semi-gods, that they can never be asked anything. Mr. Speaker, time has come that this Senate must restore the dignity of this House. And I say this, Mr. Speaker, well aware that I've seen today that there are things happening in Nandi. I've seen, Mr. Speaker, that there are things happening in Nyandarua. Mr. Speaker, I want to call upon members of the county assemblies to demand nothing less than accountability from their governors. I thank you, Mr. Speaker.
Thank you, Honorable Speaker. First and foremost, I want to join my colleagues also. For one, I want to support the statement from Senator Izzy. Honorable Speaker, I think many times the House have discussed issues to do with the disappearance of Kenyans. It's actually a very unfortunate situation. And what is going on in this country, I think the security of this country is going out of hand. And it's the high time that the security officers must take charge of the security of this country. There are so many foreigners who have now made Kenya as a heaven, enjoying all that, and they do what they can do at their own way. There are so many people who run away from their countries and now hiding in this country, investing in this country, the money looted from other countries. I think it is a high time we need to audit who is who in Kenya, so at least we can be safe. As it is, every day you are hearing somebody has been killed. Every day people are disappearing, and you don't know who is doing it. So it's a high time that we need to take charge of this country, and security officers must take charge of this country. And we must know who is a foreigner and who is a Kenyan, because we are not able to know who is who. For the case of the governors, Honorable Speaker, as the chair of the devolution, actually it's a very unfortunate situation. What is going on? Because this House, the Senate is there to oversight counties. It's our mandate. Even if you are called 100 times, the governors must appear to answer whatever is happening in their counties. Otherwise, as it is, what is going in this county, this country today, money in the counties, actually, you struggle hard, you are giving them no money, you are working for them, we fight for the rights of the counties, but unfortunately, they see the senators as unfriendly members, and that should not be the case. I know they are not all the same. Some of them are law-abiding, but I think what is happening now, like the likes of the Solo, is very unfortunate, Honorable Speaker. The other day, I received a call from members of the MCAs from Solo, and some of them have been removed from committees by the governor and his team. Actually, that's going too low. The governor has no business managing the assemblies. So it's a high time, and I think we have still some lacunas in the county government acts that we need to look at it and rebuild. So at least we can be able to have where we can have action, take action against the governors. Because now, even impeachment, we bring them, they're impeached, they run to the courts, and they're still working and they're free. So I think there is a bit of, we have to review the law. With this remark, I beg to support the statements of Honorable Sergei. Thank you so much, Honorable Speaker.
Okay. Mr. Speaker, thank you for this opportunity. Number one, Mr. Speaker, I wanted to comment about the statement by Senator S.O. Kenyuri. Mr. Speaker, as a young person in this country, Mr. Speaker, it breaks my heart when constantly it seems as though we cannot be able to contain the problem of abduction of young people. And Mr. Speaker, I wanted just to inquire whether there is anything this House can do for resolutions that we have passed, and especially at a presidential level, Mr. Speaker, that aren't followed through. Because, Mr. Speaker, in July, we did pass a resolution here at the heart of chaos in this country. And those resolutions, Mr. Speaker, went to the president of this country. And among the issues that were supposed to be dealt with, apart from just compensation of young people who were affected during the Gen Z movement, Mr. Speaker, we also implored upon the president, Mr. Speaker, that the issue of abductions be responded to very strongly, Mr. Speaker. The reason why I'm bringing this, Mr. Speaker, is because the abductions that are happening. Thank you, Mr. Speaker. Mr. Speaker, the reason why I'm bringing this up is because the abductions that are happening in this country are happening at two levels. One, within structured authorities of governance in this country, and number two, outside those structures. But I think that if there is a force in dealing with the issues of abductions within structure of security in this country, Mr. Speaker, there will be an equal response to those who are doing it outside the structure, Mr. Speaker. And therefore, Mr. Speaker, I wanted to inquire, and perhaps the majority leader can help us on this, Mr. Speaker, that if we end up having some resolutions in this House, Mr. Speaker, that can be able to pick on some of these issues that we are seeing in terms of abductions in the country, Mr. Speaker, that sometimes end up affecting the security infrastructure, Mr. Speaker, can we know how, if they're not responded to, Mr. Speaker, thank you, Mr. Speaker. And I think that it starts by making sure that the abductions that happen within the security infrastructure in this country, Mr. Speaker, are dealt with for once and for all, Mr. Speaker, so that those who are doing it outside the security infrastructure can take it more serious, Mr. Speaker, that you are saying point of order and young people are dying outside here, young people are being abducted, and they're becoming uneasy when there is no security infrastructure in the country.
What is your point of order, Senator Oro? We have heard you.
You're just shouting.
Mr. My mic. My mic. Hi.
I can lend you mine.
Mr. Speaker, understanding Order 105, I have listened to Senator Eddie Okech talking about abductions happening within the structures of government and outside other structures. And Mr. Speaker, you know, there is an allegation there being placed on, I'm not even sure whether he's targeting an individual in government, whether he's, because he has also mentioned the president at one point. Can he substantiate these structures within government where he's saying that are being used for abduction? Perhaps he knows of a unit, a particular unit that he can even just mention, so that even us as senators, we can come out and call out that unit. We would like to know which is this inside government, maybe, and if he cannot substantiate, he must apologize and withdraw, because this is the upper house. This is not the National Assembly. This is a house of records, a house of procedure, and we carry ourselves with facts. Mr. Speaker, let him substantiate.
Mr.
Which you have to substantiate. The structured abductions.
Mr. Speaker, Mr. Speaker, Mr. Speaker, I was very clear about the document which is a resource of this House that has gone to the President. In that document, we were very clear about a number of issues that we complained about. Unless Senator Gloria was not in this House to listen to what was being discussed in this House, Mr. Speaker, I am very clear in my mind, Mr. Speaker. And Mr. Speaker, let me say this, Mr. Speaker. Maybe Senator Gloria is comfortable because any of her family members have never been abducted. But abduction of young people in this country must stop. And they happen within the structure of security in this country as well as outside the structure of this country. You might make noise as much as you want, but I can assure you that one day your own family member or your own relative will be abducted and you won't be sitting pretty. We must stop the abduction of young people in this country. It must stop.
Order, Honorable Senator. Senator Eddy, order. Senator Fernandez, take your seat. Now, order, Senator Joyce Correct. Order, Honorable Senator. This is the House. Senator Eddy, you are supposed to address the chair, not your colleagues. You've been called upon to substantiate an allegation that you've made. Order, honorable senators.
Mr. Speaker.
Sit down, Senator Eddy. Where are you going? Sit down. Sit down, sit down. The chair is speaking. Senator for Kilifi, let the chair handle this. Now, Senator Roba rose on a point of order on this allegation that you've said there are structured abductions within the system. So, you've been called upon to substantiate those allegations. What did you mean by structured abductions within government? Instead of responding to that, you've been shouting back at your colleagues. Proceed, Senator Eddy, to substantiate. If you're not in a position to do that today, you know exactly what to do.
Mr. Speaker. Mr. Speaker.
Can the senator be heard inside?
Mr. Speaker, it is not my role as a senator of Migori to focus the Senator Oruoba in this House. I refer to a resolution of this House, Mr. Speaker, that is a property of the House passed by all of us. And that resolution, Mr. Speaker, that resolution, if you read it, Mr. Speaker, it talks about abductions and killings that this Senate was tired of, addressed to government. Mr. Speaker, if it is addressed to government, Mr. Speaker, and it has not been responded to, Mr. Speaker.
Senator Eddy, order. Senator Joyce, I caution you. You proceed, I'll throw you out of the chamber. Now, Senator Eddy, look for that document and read the particular resolution that you're relying on. And I'm giving you to do that tomorrow. You may not be able to get the document right away. Look for that document and read that particular resolution that supports your allegation.
Mr. Speaker,
let's proceed. Have a seat.
Mr. Speaker, I hadn't finished. They ate on my time, Mr. Speaker. They ate on my time.
Sit down. Take your seat.
Mr. Speaker, you're giving them so they ate on my time.
Take your seat. Senator Omtata. Senator for Kilifi, you know there is no senator on their feet. You cannot raise on a point of order.
No, he was still standing there.
Yeah, but he... Proceed. I did not refuse you. You don't catch my eye. Proceed, Senator Omtata.
Mr. Speaker, sir, thank you for the opportunity. The question of abductions is a very serious question. Kenya is a republic, a government of law, and you have got institutions that have been mandated to take care of the security of the citizen. And these institutions are basically, in terms of civilian order, the police. Our streets cannot be an area where people can abduct others, disappear others, run illegitimate detention centers, and then release them, and there are no consequences. When these people are released, Mr. Speaker, sir, I have not heard of any incident whereby the abductees have been guaranteed security and the government security apparatus summoned them to a debriefing to try and identify where they were being held and why they were being held. And that points to collusion by the police in the ongoing abductions. To make matters worse, Mr. Speaker, sir, it's a matter of fact that the capacity of the police to investigate this kind of activities, if at all they involve the police forces, has greatly been eroded. And this was done deliberately under the last command of Inspector General Koome, whereby officers who are trained to deal with this kind of matters and who are housed at the internal affairs internal affairs unit of the National Police Service were systematically transferred out of station. The unit was starved of funds, and it's a pale shadow of what it was when it was set up, with the intention that should any security forces step out of the law, they would be dealt with by the fellow policemen. So, Mr. Speaker, sir, whereby when you don't get the government taking action to debrief those who have been abducted and released, to establish where exactly they were being held, to try and determine who are holding them, then the only conclusion you can draw is that the security forces have failed in their mandate, and for lack of a better word, are complicit in the abductions. And so, Mr. Speaker, sir, the circumstantial evidence that avails itself to an inquisitive eye is that our abductions are being conducted either by the police or with the full knowledge of the police command. And
what is the point of order, Senator Fernandez?
Mr. Speaker, I raise understanding order 105. While I agree that the issue of abductions is a very serious issue in the country, you cannot allow Senator Okia Omtata to get away with what he's saying by saying that the abductions that is happening within the country are either state sanctioned or police sanctioned. And talking about defunding a unit. Mr. Speaker, can the senator of Busia table evidence to show that there is complicity or the police are tolerating the abductions that is happening currently in the country, so that we can move forward? If he can table, Mr. Speaker, then we move forward, because he's a litigant. He knows in court you don't carry gossip before a court of law, Mr. Speaker. He must substantiate. This is not a market, Mr. Speaker. This is not a market. This is not a marketplace, Mr. Speaker, where you bring the gossip, Mr. Speaker. Mr. Speaker, can you protect me? Mr. Speaker, can you protect me, Mr. Speaker?
No,
can you protect me?
Senator Fernandez.
This is not heckling
Senator
arena.
Fernandez, you've made your case. Take a seat. Now, Senator Omtata, proceed to substantiate your allegations. To who? To inform who? Who? Just let Senator Omtata proceed to substantiate.
You want to inform me?
We have a lot of business ahead of us.
Yes, the issue is the word substantiate. It seems to be an exciting word to some people in this house. When I submitted, I said circumstantial evidence, and I pointed to the circumstantial evidence that I was saying should not be ignored. The circumstantial evidence that none of the people who have been abducted and released has been called to the police for debriefing to establish what has happened. Number two is a statement of fact, and there have even been complaints about the funding of the internal affairs unit of the police.
Which evidence?
Point number 3, the internal affairs unit has had its officers transferred, and this happened under Inspector General Koome. So, as far as I'm concerned, you don't substantiate the obvious.
Mr. Speaker, point of order, we table the This guy is not human resources.
You cannot table evidence that something did not happen.
Mr. Speaker, it's not human resources.
You cannot.
No, Senator Mutati.
Yes.
You're not going to exchange with the senator.
I'm not exchanging, I'm talking to the chair. I'm choosing not to listen to a heckler.
I'm in charge of this house, and if you need protection, I'll give it to you. Just proceed.
You are a professional heckler.
Mr. Speaker, sir, thank you very much. The issue is, I cannot substantiate what did not happen. I said the police have never called any of the people who were abducted and released to a debriefing for them to tell them where have these people been. The only thing that can happen is for Senator Cherargei to come up with evidence that the police have done that. When I say it has never happened, you cannot ask me to substantiate what never happened.
No, you are being clever by half.
I'm a clever man.
Clever by half.
Senator Fonambi, I'm cautioning you.
So, I have not said anything that requires substantiation.
Conclude, Senator Mutati.
So, Mr. Speaker, sir, the issues of abductions are very serious matters, and we need, as a house, maybe to have a special sitting where we can summon our security forces, because recently it was reported in the media that the Inspector General of Police said he was not aware of who was abducting people. Yes. So we need them to be summoned to this house to come and tell us why the police has lost control of the security of this country.
Your 3 minutes time is up.
Thank you, Mr. Speaker, sir. I have nothing else to submit. I'm happy to see the majority leader very calm.
Now, honorable senators, that marks the end of the intervention of the statements. Now, allow me, pursuant to Standing Order 45-2, to rearrange today's order paper. We will move to handle order number 15, 16, 17, 23, and 24 before we resume normal flow as contained in today's order paper. Clerk, you may proceed to call those orders.
Order number 16, order number 15, Committee of the Whole, the Meteorology Bill, Senate Bills number 45 of 2023. Order number 16, Committee of the Whole, the National Construction Authority Amendment Bill, National Assembly Bills number 59 of 2022. Order number 17, Committee of the Whole, the Cancer Prevention and Control Amendment number 2 Bill, National Assembly Bills number 45 of 2022. Order number 23, Committee of the Whole, the Political Parties Amendment number 2 Bill, Senate Bills number 26 of 2024. Order number 24, Committee of the Whole, the Election Offenses Amendment number 2 Bill, Senate Bills number 28 of 2024.
Lazima tuguane kidogo. Hiyo resolution lazima ikuje kwanza. Sawa chama. Hiyo ni uongo. Walisema MP, mimi ni senator. Hakuna. No.
Currently, yes. Unaweza.
Is it working? Viposhuka kumzee mzako hivyo. Kuna namba?
Beatrice.
What's happened?
Tabs. We don't have a speaker. The thing to go division. We don't have the rule of division. Oh, yeah. This is the speaker. The number of bills, sio moja. Don't give you the moment to kind of
Order. Order, senators. We're going to order number. Order, honorable senators, order, please take your seats. We are about to begin. Order number 15, clerk.
Order number 15 is the meteorology bills, Senate bills number 45 of 2023. And we are going to the clauses, clause 3.
Majority Leader, clause 3.
Oh yeah, it's working.
Majority Leader, just one moment, please. Clause 3, I propose the question that clause 3 be part of the bill. Mover.
I propose the question that clause 3 be amended as proposed.
I put the question that clause 3 be amended as proposed, division at the end. Clause 4, 5, and 6.
Clauses 4, 5, and 6.
I propose the question that clause 4, 5, and 6 be part of the bill. I put the question that clause 4, 5, and 6 be part of the bill, division at the end.
Clause 7.
I propose the question that clause 7 be part of the bill. Mover. Majority Leader.
Be amended as proposed in the order paper.
I propose the question that clause 7 be amended as proposed. I put the question that clause 7 be amended as proposed, division at the end.
Clauses 8 to 15.
I propose the question that clauses 8 to 15 be part of the bill. I put the question that clauses 8 to 15 be part of the bill, division at the end.
Clauses 16 to 25.
I propose the question that the clauses 16 to 25 be part of the bill. I put the question that clauses 16 to 25 be part of the bill, division at the end.
Clauses 26 to 35.
I propose the question that clauses 26 to 35 be part of the bill. I put the question that clauses 26 to 35 be part of the bill, division at the end.
Clause 36.
I propose the question that clause 36 be part of the bill. Mover, Majority Leader.
Honorable Chairperson, I propose that clause 36 be part of, be amended as proposed.
I propose the question that clause 36 be amended as proposed. I put the question that clause 36 be amended as proposed, division at the end.
Clause 37.
I propose the question that clause 37 be part of the bill. Majority Leader.
Honorable Chairperson, I propose that clause 37 be amended as proposed.
I propose the question that clause 37 be amended as proposed. I put the question that clause 37 be amended as proposed, division at the end.
Clauses 38 and 39.
I propose the question that clause 38 and 39 be part of the bill. I put the question that clause 38 and 39 be part of the bill, division at the end.
Clause 40.
I propose the question that clause 40 be part of the bill. Majority Leader.
Honorable Chairperson, I propose that clause 40 be amended as proposed.
I propose the question that clause 40 be amended as proposed. I put the question that clause 40 be amended as proposed, division at the end.
Clauses 41 to 51.
I propose the question that clauses 41 to 51 be part of the bill. I put the question that clauses 41 to 51 be part of the bill, division at the end.
New clause 8A.
Majority Leader.
Honorable Chairperson, I beg to move that the new clause 8A be now read a second time.
I propose the question that new clause 8A be now read a second time. I put the question that new clause 8A be now read a second time, division at the end.
New clause 8B.
Majority Leader.
Honorable Chairperson, I beg to move that the new clause 8B be now read a second time.
I propose the question that new clause 8B be now read a second time. I put the question that new clause 8B be now read a second time, division at the end.
New clause 8C.
Majority Leader.
Honorable Chairperson, I beg to move that new clause 8C be now read a second time.
I propose the question that new clause 8C be now read a second time. I put the question that new clause 8C be now read a second time, division at the end.
The first schedule.
I propose the question that the first schedule be part of the bill. I put the question that the first schedule be part of the bill, division at the end.
The second schedule.
I propose the question that the second schedule be part of the bill. Majority Leader.
Honorable Chairperson, I propose that the second schedule be amended as proposed.
I propose the question that the second schedule be amended as proposed. I put the question that the second schedule be amended as proposed, division at the end.
The third schedule.
I propose the question that the third schedule be part of the bill. I put the question that the third schedule be part of the bill, division at the end.
Clause 2.
I propose the question that clause 2 be part of the bill. I put the question that clause 2 be part of the bill, division at the end.
The title and clause 1.
I propose the question that the title and clause 1 be part of the bill. I put the question that the title and clause 1 be part of the bill, division at the end. Honorable Senators, we are now moving to the next order on the order paper.
Where is the documentation? Give me the copy. Yeah.
Okay, now we are moving to the National Construction Authority amendment. The National Construction Authority Amendment Bill, National Assembly Bills number 59 of 2022.
Majority Leader? No. Clause 2. I propose the question that Clause 2 be part of the bill. I put the question that Clause 2 be part of the bill, division at the end.
New Clause 1A.
New Clause 1A. Majority Leader?
Honorable Chairperson. Oh, the other one is working. It's Clause 1A. Yes. Honorable Chairperson, I propose that the new Clause 1A be, wait. Yeah. It's actually, Honorable Chairperson, I propose that the new Clause 1A be now read a second time.
I propose the question that new Clause 1A be now read a second time. I put the question that new Clause 1A be now read a second time, division at the end.
The title and Clause 1.
I propose the question that the title and Clause 1 be part of the bill. I put the question that the title and Clause 1 be part of the bill. Honorable Senators, we are proceeding to the next bill, the Cancer Prevention and Control Amendment Bill number 2, Assembly Bills number 45 of 2022.
Clause 2.
I propose the question that Clause 2 be part of the bill. Mover.
Is this one functioning? Okay. Mr. Speaker, that Clause 2 of the bill be amended in the proposed new definition of the word e-health by inserting the words including telemedicine immediately after the words and information technology in quotes.
I propose the question that Clause 2 be amended as proposed. I put the question that Clause 2 be amended as proposed, division at the end.
Clauses 3 and 4.
I propose the question that Clauses 3 and 4 be part of the bill. I put the question that Clauses 3 and 4 be part of the bill, division at the end.
The title and Clause 1.
I propose the question that the title and Clause 1 be part of the bill. I put the question that the title and Clause 1 be part of the bill, division at the end.
H. You need H. So we are not going to edit.
Honorable Senators, we proceed to order number 24. The Election Offences Amendment number 2 Bill, Senate Bills number 28 of 2024.
Clause 2.
I propose the question that Clause 2 be part of the bill. Mover.
Elections. No, that's number 24. No, I thought we had said Honorable Chairperson, I propose that clause 2 be part of the bill.
I propose the question that clause 2 be amended as proposed. I put the question that clause 2 be amended as proposed, division at the end.
New clause 3.
Majority Leader.
Honorable Chairperson, I propose that the new clause 3 be now read a second time.
I propose the question that new clause 2 be now read a second 3. New clause 3 be now read a second time. I put the question that new clause 3 be now read a second time, division at the end.
New clause 4.
Majority Leader.
Honorable Chairperson, I beg to move that the new clause 4 be now read a second time.
I propose the question that new clause 4 be now read a second time. I put the question that new clause 4 be now read a second time, division at the end.
The title and clause 1.
I propose the question that the title and clause 1 be part of the bill. I put the question that the title and clause 1 be part of the bill, division at the end.
It's not 23, it's 20. No, it's number 20 of the order paper. 20? But it was not called. It wasn't called from the house. No, it's okay then. Unlike we do the divisions, we don't have, so we can put them for tomorrow. Yes. Then we just have to talk about them. There's no speaker to report. When is speaker alienda? Ilikuwa nani?
Sigeri, lakini is coming in at 5.
Okay, we can begin through the motions. Let me just see
which motions?
Through the motions.
Nataka ni contribute ya nini? Nataka ni contribute ya basa.
Ah, jana hiyo mtetuga basi na tete mjinga.
So what is next?
Ngia namba arambe.
Sawa. Answer us.
No, so we start with the election amendment. Alafu
did I contribute? So when we maliza elections amendment.
Unasema? We report progress. But we can't report to him. Sorry? Oh, yeah. Yes, let's do it. Okay. Proceed. Yeah. Report it.
I call upon them. So I can go to the chair,
yeah,
and he will talk to the speaker.
So.
The Meteorological Bill, Senate Bills number 45, 2023. Majority Leader, move to report.
Honorable Chairperson, I beg to move that the committee do report to the Senate its consideration of the Meteorology Bill.
I put the question that the committee do report to the Senate its consideration of the Meteorological Bill, Senate Bills number 45 of 2023, and its approval thereof with amendments. As many as of that opinion say aye. Aye. As many as of the contrary opinion say nay. The ayes have it.
Don't leave. Because we haven't. Yeah. Sorry. Honorable Chairperson, I beg to move. Honorable Chairperson, pursuant to Standing Order number 153, I beg to move that the Committee of the Whole do report to the Senate its consideration of Meteorology Bill, Senate Bill number 45 of 2023, and seek leave to sit again tomorrow.
Senators, I put the question that the Committee of the Whole do report to the Senate its consideration of the Meteorological Bill, Senate Bills number 45 of 2023, and seek leave to sit again tomorrow. As many as of that opinion say aye.
Aye.
As many as of the contrary opinion say nay. The ayes have it. National Construction Authority Amendment Bill, National Assembly Bills number 59 of 2022. Mover.
Honorable Chairperson, pursuant to Standing Order number 153, I beg to move that the Committee of the Whole do report to the Senate its consideration of the National Construction Authority Amendment Bill, National Assembly Bill number 59 of 2022, and seek leave to sit again tomorrow.
I put the question that the Committee of the Whole do report to the Senate on its consideration of the National Construction Authority Amendment Bill, National Assembly Bills number 59 of 2022, and seek leave to sit again tomorrow. As many as of that opinion say aye.
Aye.
As many as of the contrary opinion say nay. The ayes have it. The Cancer Prevention and Control Amendments Bill number 2, Bill National Assembly Bills number 45 of 2022. Mover.
Mr. Speaker, Honorable Chair, pursuant to Standing Order 153, I beg to move that the Committee of the Whole do report on its consideration of the Cancer Prevention Bill and seek leave to sit again tomorrow.
I put the question that the Committee of the Whole do report to the Senate on its consideration of the Cancer Prevention and Control Amendments Bill, National Assembly Bills number 45 of 2022, and seek leave to sit again tomorrow. As many as of that opinion say aye.
Aye.
As many as of the contrary opinion say nay. The ayes have it. Honorable Senators, we move to the Election Offences Amendment Bill, Senate Bills number 28 of 2024. Mover.
Honorable Chairperson, pursuant to Standing Order number 153, I beg to move that the Committee of the Whole do report on its consideration of the Election Offences Amendment Bill, Senate Bill number 28 of 2024, and seek leave to sit again tomorrow.
I put the question that the Committee of the Whole do report on its consideration of the Election Offences Amendment Bill, Senate Bills number 28 of 2024, and seek leave to sit again tomorrow. As many as of that opinion say aye.
Aye.
As many as of the contrary opinion say nay. The ayes have it.
Mr. Speaker.
Proceed. Acha aende.
Report to Sawa. I think we are
now will report the
report. To report here to
So, do you know the big deal? The big percent of the election? Okay. What's the big deal? Okay.
Yeah.
Speaker, umekuwa wapi?
Now, honorable members, we are proceeding to report the progress of the Committee of the Whole, and I call upon the chairperson to report.
Thank you, Mr. Speaker, sir. I put the question that the committee, thank you, Mr. Speaker, sir. I beg to report that the Committee of the Whole has considered the Meteorological Bill, Senate Bills number 45 of 2023, and seek leave to sit again tomorrow.
Mover.
Yeah, Honorable Speaker, I beg to move that the House do agree with the committee on the said report.
Somebody to second. Will be seconded, please.
I beg Senator Cherargei to second.
Honorable members, now I propose the question that the House do agree with the committee in the said report, and I put the question that the House do agree with the committee in the said report. Will as many as of that opinion say aye?
Aye.
Yes, will as many as of that opinion say aye?
Aye.
Will as many as of a contrary opinion say nay? The ayes have it. Okay, number 2, yes. Now we are proceeding to the next bill, that is the very well. The next bill that we are dealing with is the National Construction Authority Amendment Bill, National Assembly Bills number 59 of 2022, and I will call upon the chairperson to report.
Honorable Speaker, I beg to report that the Committee of the Whole has considered the National Construction Authority Amendments Bill, National Assembly Bills number 59 of 2022, and seek leave to sit again tomorrow.
The mover, Majority Leader.
Honorable Speaker, I beg to move that the House do agree with the committee on the said report. I request Senator Cherargei to second.
Honorable members, I now propose the question that the Senate do agree with the Committee of the Whole in the said report, and I put the question that the Senate do agree with the Committee of the Whole in the said report. Will as many as of that opinion say aye?
Aye.
Will as many as of a contrary opinion say nay? The ayes have it. We shall proceed to the third bill for consideration, that is the Cancer Prevention and Control Amendment number 2, Bill, National Assembly Bills number 45 of 2022. I'll call upon the chairperson to report.
Honorable Speaker, I beg to report that the Committee of the Whole has considered the Cancer Prevention and Control Amendments number 2 Bill, National Assembly Bills number 45 of 2022, and seeks leave to sit again tomorrow.
The mover.
Honorable Speaker, I beg to move that the House do agree with the committee of the said report, and I request Senator Chute or Shute to second.
I second, Chair.
I now propose the question that the House do agree with the committee in the said report, and I put the question that the House do agree with the committee in the said report. Will as many as of that opinion say aye?
Aye.
Will as many as of a contrary opinion say nay? The ayes have it. The next bill for consideration, honorable members, for reporting is the Election Offences Amendment number 2, Bill, Senate Bills number 28 of 2024. I ask the chairperson to report.
Honorable Speaker, I beg to report that the Committee of the Whole has considered the Election Offences Amendments Number 2 Bill, Senate Bills Number 28 of 2024, and seeks leave to sit again tomorrow.
Mover, the Majority Leader.
Honorable Speaker, I beg to move that the House do agree with the committee on the said report. I request Senator Chute to second.
Honorable Speaker, I second.
Honorable members, I now propose the question that the House do agree with the committee in the said report, and I put the question that the House do agree with the committee in the said report. Will as many as of that opinion say aye? Aye. Will as many as of a contrary opinion say nay? The ayes have it.
We are busy doing the business.
Cross tu hakuna shida. When speaker.
So, honorable members, we will now revert back to the normal order as per the order paper, and the clerk, you call the next order. Next order number. Actually, order number 8. Yeah, order number 8.
Order number 8, motion, report of the Select Committee on County Public Investments and Special Funds on its consideration of the audit reports of the water services providers for financial year ended 30th June 2019, 30th June 2022, and 30th June 2021. Resumption of debate.
Honorable members, when the House adjourned on the 12th of November 2024, Senator Osotsi, who is the mover of this motion, was to reply, and I now call upon Senator Osotsi to proceed to reply.
Thank you, Mr. Speaker. Mr. Speaker, first of all, I want to start by thanking the members who overwhelmingly contributed to this important motion on matters of water service providers. A number of issues came up, Mr. Speaker, which I would like to quickly address before I reply. There was the matter of late submission of documents, which is guided by Section 62 of the Public Audit Act, and this has become a problem where certificates for audit reports are issued by the Office of the Auditor General, and then when they appear before Senate committees of PIC and PAC, they carry big files of evidence. Most of those documents are questionable. So the matter of late submission of documents, we have agreed that moving forward, we will not accept evidence in form of documents which are submitted during the Senate hearing. Those documents needs to be submitted within the audit circle. There was also the issue of how to mitigate the higher non-revenue, which in most counties is beyond 25%. And members felt that there is need to automate the metering system by having smart meters, and also the need to apply GIS solutions in terms of managing of water networks. There was also the common problem of errors in financial statements, which are attributed to capacity issues and training within the finance department. And Mr. Speaker, we have the Public Sector Accounting Standards Board that prescribes the format in which the financial statements should be submitted. And we have recommended that moving forward, all counties must align their financial statement to the Public Sector Accounting Standards Board. There was also the common issue of non-remittance of statutory deductions by these companies. And Mr. Speaker, this is a compliance issue and an offense. And we have directed that the counties involved to make sure that they submit their financial statements in time. The matter of transfer of assets and liabilities for these water companies was also a major issue, and IGRTC has been handling this matter, Mr. Speaker, but it's taking too long. I think it's important for these water companies to have their assets in their name so that their financial statements are not overstated. There was also the matter of declustering and clustering, which we reported that Bungoma and Trans Nzoia are now in the process of completing their declustering process so that they have separate water companies. The same applies to Kisii and Nyamira, Mr. Speaker. The specific issues, Mr. Speaker, that came up, for example, for Bomet County, was the matter of a project by the name Kamreito Water Supply that is under which we referred to EACC for investigation, Mr. Speaker. There was also a serious problem with unlimited statutory deductions amounting to about 12.9 million. The issue of accuracy and recoverability of outstanding trade receivables amounting to 219 million. This matter, again, Mr. Speaker, has been referred to EACC for further investigation because we cannot have this huge amount of money not recovered and whose supporting documents are not available. The matter of the stalled Chebuntoyo Siogoi water project, which has stalled for many years, Mr. Speaker, amounting to 17.5 million. Again, this matter was referred to EACC. The matter of Gusii water, which is under Kisii County and Nyamira, we had a whooping 39.6 million as trade payables. Again, this matter, Mr. Speaker, we gave recommendations that these trade payables be reduced. The non-revenue water in this particular company is one of the highest at 46%, Mr. Speaker, with a wage bill of 69%. Kisumu Water, this is one of the most successful water companies, but aside, we have issues with internal controls, especially on the matter of exhauster revenues, how ticketing is done, and how the movement of the exhauster is managed, leading to loss of company funds. Unrealistic budgets and plans, and of course, high non-revenue water. Kwale Water, Mr. Speaker, also, the issue that was noted was a lack of budget control and performance, which resulted into a revenue shortfall of 40 million shillings. And also the high non-revenue water that stands at 57%. And again, the matter of unsupported debt with the coast water services amounting to 180 million shillings. Mr. Speaker, Vihiga County, Amazi Water Company, it was noted that they have a long outstanding receivables of 63 million shillings and inaccurate trade and other payables amounting to 50 million shillings. This matter was noted and passed to EACC for further interrogation and investigation. Mr. Speaker, Nyeri County, this is Nyeri Water Company, which had debts totaling, outstanding debts totaling to 237 million, which has been outstanding for long. And again, this is linked to the Water Works Company. So, Mr. Speaker, I want to commend the members who participated in this debate and to say that this is the first report for water company that my committee has submitted to this House. We still have another 5 more motions to go on this matter. I hope we'll have those motions debated and adopted by this House before we go for recess, so that next year the committee can start handling the current issues, that is for the year 2022-2023 and 2023-2024, 2023-2024 and 2024-2025. Mr. Speaker, I want to commend my committee because this is the first report that a committee of Senate has tabled on matter of audit reports for water company. And I want to say that because of this, we are beginning to see some improvement in governance of water companies in our counties. But we still have challenges. The issue of ownership of this company, we have managed to ensure that almost all water companies are now owned by county government. Before, these water companies were either owned by crooks in our counties or people who are not county government. But through the intervention of this committee, I am happy to report that most counties have now complied. I am also happy to note that one of the water companies which was being run by private individuals in Murang'a, that is the Murang'a Water Company, and that is one of the most successful water companies, has now been reverted fully to the county government of Murang'a, and many, many other cases. So, Mr. Speaker, I know we are having cross-cutting issues that we identified. They are not necessarily audit issues, but that will be presented to this House in a separate report on matters of water management in our counties. Mr. Speaker, I do not want to go beyond that to say that I beg to reply and request that the putting the question be rescheduled to another date.
Standing order number 663.
Oh, you were asking me about Garissa. Garissa is in a different report, which is coming.
Yes.
Yeah.
A request for deferment of division.
Yeah, he has asked for it.
Oh.
Standing order?
You did it, 66-3.
Yeah, 66-3.
Thank you, Senator. It is so deferred. Next order.
Next one, order number 25. Is that rain? Kunanyesha?
Rain? Yes, clutch. Is it raining?
Honorable Senators, I further rearrange the order paper so that we go to order number 25. Clerk.
Order number 25, the Elections Amendment number 2 Bill, Senate Bills number 29 of 2024, second reading.
Majority Leader.
Thank you. Mr. Speaker, I beg to move that the Elections Amendment number 2 Bill, Senate Bill number 29 of 2024, be number 29 of 2024, be now read a second time. Mr. Speaker, this is a very interesting legislation. I have been at the Bomas of Kenya in 2013, 2017, and 2022, Mr. Speaker. As an party, it's really unfortunate. In fact, I'm speaking like this, Mr. Speaker, because we've just watched elections in the first world. That elections were held. I'm speaking like this, Mr. Speaker, because we've just watched elections in the first world. That elections were held. More than 150, I think 130 million people voted, Mr. Speaker. And by 3, 4, 5 hours after that, you get an indication of who has taken the lead. They, in fact, if you have an interesting candidate like the President-elect of the United States, Mr. Speaker, he did not even wait for other states to declare the results. Once it became apparent, Mr. Speaker, that he was going to garner the magical 270 electoral college, Mr. Speaker, he went ahead and gave his victory speech. And the losing candidate also held back for a while, and eventually, less than 24 hours after the election, gave her concession speech, and life moves on, Mr. Speaker. In even more advanced democracies, Mr. Speaker, because a few months ago, I was in the UK when they were voting, and immediately, even on election day, you could hardly tell that there is any electoral process that is ongoing, Mr. Speaker. This intense litigation, agitation, and the fights that we have at Bomas, Mr. Speaker, are all a product of trust deficit. And the many legislations that we have passed here over the years in this House, most of the time, just a few days to election, Mr. Speaker, are to address some of these fears. And one of the things that I must appreciate about this bill that came out of, I must first declare, Mr. Speaker, that this is one of the so-called NADCO bills that came out of a negotiated dialogue process at the Bomas of Kenya, where yours truly was part and parcel of the team that sat there, and we had representation from the Azimio coalition, Mr. Speaker, and the side of Kenya Kwanza, Mr. Speaker. And there are many things that we felt Kenyans, when they came and made presentations before us, they continue to raise about our electoral processes, Mr. Speaker. You listen to some of the proposed laws, Mr. Speaker, that are being added into our election laws. If you are not careful, Mr. Speaker, our election law book may end up being the largest in the world very soon, Mr. Speaker, by the very simple principle that we want to put it in writing even the minutest of procedure, something that to other countries and to other people are rather obvious. But given that we are an extremely litigious country, and our judiciary doesn't help our cause, Mr. Speaker, because they agree even with people that you'd consider nuisance litigants, Mr. Speaker, who raise issues that are so mundane. But then, in typical fashion of our judiciary, sometimes, Mr. Speaker, they agree with them and they say, yeah, it's not written in law, it's not in our constitution, and therefore the petition has succeeded, Mr. Speaker. And therefore we ended up litigating on very minute details of our electoral process, as such that in other countries, Mr. Speaker, are not things that people contest or consider about, or argue about, Mr. Speaker. But given that this is our home, we don't have another home. We are the people. There are no other people, Mr. Speaker. We have to learn to live the way we are accustomed to live with each other. And therefore, Mr. Speaker, in the various clauses that form part of this bill, there are actually about, 39 sections that are in this particular bill, Mr. Speaker. You will see and find yourself addressing many of the issues that have been of concern to Kenyans. And therefore, as we read about and give proposals in this particular bill, I hope that the House will eventually agree with us and put this in legislation. One last thing, Mr. Speaker, before I get into the details of the bill, that I appreciate about the genius of this legislation is that in all other elections, from 2017 and 2022, Mr. Speaker, we have fought in this House while trying to amend election laws, Mr. Speaker, a few months to the election time. Yet we know, if you read part of our election management processes, Mr. Speaker, what forms the basis of many of the electoral processes, Mr. Speaker, is a Kriegler, the so-called Kriegler report that came up after the disputed 2007 elections. And one of the so obvious and quoted phrases and recommendations in that particular report, Mr. Speaker, is the fact that we as Parliament were indicted for changing electoral management processes laws just a few months to the electoral cycle, Mr. Speaker, that we do deals last minute that make it impossible or difficult for election managers, Mr. Speaker, to conduct our elections to the satisfaction of the country. And you know very well, Mr. Speaker, that we have perhaps the highest standard of election expectation, Mr. Speaker, in comparison with the rest of the world. We expect a near-perfect process, let alone the fact that you know that it's run by human beings, Mr. Speaker, who many a times they enter these results deep in the night, having not slept for more than 3 hours, but we argue none the same, Mr. Speaker. And therefore, it is important to note that this time we have made the decision to make these laws more than 3 years before a general election, Mr. Speaker. And that is quite commendable, because it basically means, or about close to 3 years, Mr. Speaker, because it basically means that the Independent Electoral and Boundaries Commission, Mr. Speaker, will have sufficient time to acquaint themselves with all the provisions, Mr. Speaker, of our laws, as such that as they prepare to take the country into an election, Mr. Speaker, they will have learned of all our expectations, unlike has been the case previously, where we have amended election laws even 2 or 3 months before an election, and subsequently after that election gone ahead to fight and ask the IBC why they didn't do this or the other, of course ignoring the very obvious and basic fact that they did not actually have sufficient time to prepare. Let me get into the provisions of the bill, Mr. Speaker. Clause 2 of this bill proposes to amend Section 2 of the Act, which is election laws, Mr. Speaker, by providing for new definitions of terms of nomination, which is the term such as you insert, for example, a simple word. Remember what I mentioned earlier, that we argue even on some of the very basic things, that instead of just prescribing and saying that to vote you need a Kenyan passport, we want to propose it further and say that it must be valid, and therefore you have to put it in law. I don't think there is any other country where you'll find this in their legislation. But this is Kenya, like I've mentioned, and I've given a good history of how we find ourselves with this kind of arguments. And therefore, we want to make it clear in black and white that if you're using your passport as your primary tool of identification, then it must be valid. Rather too obvious for me, Mr. Speaker, but hey, that's who we are as a people. Let's proceed. Clause 3 of the bill, Mr. Speaker, is an amendment actually to Section 5 of our Act, which provides for registration of the voters. This is a point, Mr. Speaker, where there is a by-election. Another very, I lack the proper English vocabulary, Mr. Speaker, to actually explain this, but we have to do it anyway, because, like I have said, this is Kenya. You know, in Section 5 of the Act, Mr. Speaker, I'm not sure Senator Bodi Halwale has sufficient vocabulary for this as well. Neither does my good friend Crystal actually have. Because you know that when there is a by-election, Mr. Speaker, we freeze the registration of voters in that particular electoral area. And it's part of our election regulations, but there was need and the feeling that you must make it actually an issue of statute, not just regulation, so that people know that any time there is proposed to be a by-election in a particular area, you freeze registration of voters in that particular election, in that particular region, and actually provide clarity. Listen to this, Senator Crystal, that the restriction is only in the geographical area where that by-election is to take place. That's Kenya for you, Mr. Speaker. So you'll find that in 3A, we'll provide that the persons registered as voters during the period when registration of voters is suspended by a reason or by election shall not be eligible to contest in electoral area affected by the by-election. Mr. Speaker, Clause 4 of the bill, Mr. Speaker, seeks to amend Section 6 of the Act, which provides for inspection of registration of voters. We are deleting subsection 1 and 2 and substituting thereof with new subsections providing for the inspection of register of voters by members of the public and rectification of particulars of voters, as well as exceptions when IBC shall not be expected to rectify the particulars of the voters. This is a usual process where they normally pin the list of registration or registered voters in a particular polling station, just providing clarity. I have pointed earlier that some of these things are either definition or we are going deeper into the law to just make it more appealing. Clause 5, Mr. Speaker, is amending Section 8A, which is a deletion of subsection 3 and provides for audit of register of voters by a professional, reputable firm for purposes of first general election after the commencement of this act. You know very well, Mr. Speaker, that we have argued about the validity of our register of voters. I don't know if in other countries they have this, Mr. Speaker. I know for a fact that you have come from observing elections, Mr. Speaker, in some land very far away from this place. I don't know in your conversations or in your exit report, they had any conversations about audit of the registered list of voters. And therefore, because we don't trust or for some reason we want to confirm, we have provided that a professional audit firm, upon the passage of this act, Mr. Speaker, we shall expect the IBC to conduct, Mr. Speaker, an audit of the register. You know, in other countries, Mr. Speaker, that's why our elections are extremely expensive, Senator Osotsi. In other countries where you trust your independent institution, this is work that IBC on their own should have been left to do, you know, and clean it up. But of course, given the fact that we have provided, and remember the issue, you know, trust is an expensive affair. And I had explained why many of these issues actually stem from mistrust of the electoral process and the players in between. You can imagine how much it will cost the IBC to hire a firm to look into the list of registered voters. I think they're about 20 million, if I'm not wrong, or about thereabouts. Me and you and the Kenyan taxpayers will pay quite a tidy amount for that particular provision. But hey, let it be as it may. Clauses 6, 7, 8, 9, 10, 11, and 12 and 13 of the bill is an amendment of sections 14, 16, 17, 19, 22, 23, and 24, and actually 25, whereby deleting the word nominations and substituting it with registration of candidates so as to differentiate the role of IBC and those of the registrar of political parties. Remember, there is a confusion in how the act presently is drafted where you cannot tell which is a part. Additionally, clauses 7 and 9 delete submission of party list in respect of parliamentary and county assemblies to IBC by political, Additionally, clauses 7 and 9 delete submission of party list in respect of parliament and county assemblies to IBC by political parties. Further, clause 10 of the bill proposes to delete section 22 and set out education requirement for a member of parliament or county assembly. These requirements, remember, have been declared unconstitutional in Wamboi and 10 others by the Speaker of the National Assembly in Constitutional Petition number 28 of 2021. So we are actually eventually removing those things that we're providing for education qualifications, Mr. Speaker, because you're saying you're representing people. And therefore, many of the people you represent, Senator Alwale, are not medical doctors like you. They have voted for you on account of they feel that you can represent them. And therefore, it was a feeling of Kenyans, and the courts have finally agreed with them. And I don't think we need to push this point further, that with regards to members of a county assembly and members of parliament, that they want to elect their own. The Bible says to each their own. If they feel that they want to elect a fellow who perhaps does not meet what we would know as at least a basic standard of a competent person to legislate and represent them, Mr. Speaker, like I've said, we are only humble servants of the people, and therefore we'll allow them to have it as they wish. Clause 14 of the bill proposes to amend Section 27 by inserting a new subsection to provide that a coalition party shall within 14 days of registration submit to IBC a copy of its nomination rules certified by the Registrar of Political Parties. Remember this issue of the coalition party. We argued here on the floor of this House about coalition political parties, and the same. I'm sure after the election, Senator Okongo Mugeni has since changed his views as opposed to what he had then because of the challenges that they had in trying to run as a coalition political party. You remember the debate that was here. But at that time, you are like me. What you accuse me of being nowadays is what you were at that particular time, Mr. Speaker. Clause 15 of the bill proposes to amend Section 31, provides for nomination of political party candidates by deleting subsection 2, 2B, and 2C, 2E, and 2F, which provides that the IBC shall, upon the request of a political party, conduct and supervise nomination of candidates by the political party for presidential, parliamentary, or county elections in accordance with Article 88 of the Constitution. It's just our feeling, Mr. Speaker, that there can be a time where political parties will have matured to the level, Mr. Speaker, of allowing the IBC to actually conduct nominations for them, Mr. Speaker. And who knows, Mr. Speaker, if we were able to agree at the political parties level, Mr. Speaker, we could actually end up making it mandatory for all our political parties to do this, Mr. Speaker. But nonetheless, it's a decision of the political party. It's a right that you may not want to take it away from them. But we wanted to provide it in law, Mr. Speaker, so that if a political party feels that they don't have internal capacity to conduct a nomination process, Mr. Speaker, then they let it to IBC. Of course, I know it will be a very costly affair. I know this, Mr. Speaker, because I have run nomination, Mr. Speaker, and participated in the management of nomination of a political party, the UDA, Mr. Speaker, that conducted nomination exercises in about, I think, 40 plus counties. It's a very, very expensive affair, Mr. Speaker. Part B is you submit to the IBC the names and the person contesting the party primaries and the date of the party primaries for publication of this information in the Gazette notice. And you require also that the Parliament shall appropriate monies for the effective implementation of this section, Mr. Speaker. Such that basically what that means, Mr. Speaker, is that this exercise will be funded actually by the Kenyan public because they belong to these political parties. The only challenge is that we have provided the resources, but we have not made it mandatory for the political party to carry out its primary using the IBC. So the funds will be there, but it's the decision of the political party whether to use IBC or, Mr. Speaker, I am almost laughing when I remember about a certain political party that conducted their nomination electronically. And there was a big fight about password. Where is this password? I'm sure Senator Beatrice Ogola knows a thing or two about that password conversation that ensued actually in certain regions. So IBC has that mandate provided for in law, but upon the request of the political parties. Clause 16, Mr. Speaker, proposed to amend Section 32, which provides for the approval of a symbol for independent candidates by deleting the words nomination, day, and nomination, and substituting them with the words the date of registration and registration respectively. This is just about independent candidates and making sure that the process upon which they submit. Remember, when independent candidates want to submit a symbol which they are going to use in the election, Mr. Speaker, it's quite a long process. Clause 17 of the bill, Mr. Speaker, proposes to amend Section 33, which provides for the nomination of independent candidates. Mr. Speaker, just a few clerical things, ensuring that we clean that up. I don't intend to spend a lot of time on it. Clause 18 proposes to amend the Act by inciting new Section 33A to provide for publication in the Gazette of party candidates and independent candidates as registered to contest in a by-election. I said some of these provisions are rather too obvious, but we still must do the same. Clause 19 of the bill proposes to amend Section 34, which provides for nomination of party list members by inserting new Sections 8A and B to provide that a person can only be nominated as a member of a county assembly. If such a person is a registered voter in a ward within a county, the person is to be nominated, and the need to ensure equitable representation from all wards comprising the respective county as regards nomination. Just providing clarity. Part of what Senator Crystal Lasige was trying to do last week or a few weeks ago, Mr. Speaker, by ensuring that all persons with disabilities, Mr. Speaker, alongside all actually marginalized groups, special interest groups, that's the right word actually that I was looking for, are nominated. Further to that, Mr. Speaker, there is a practice by political parties, and includes my own political party, of imposing people who are not resident of a particular county to form part of the members of a county assembly of that county. Mr. Speaker, Mr. Speaker, I find to be completely unfair to the residents of that particular county. And therefore, I appreciate this new provision in law so that now it becomes abundantly clear that in nominating members of the county assembly, you can only nominate from registered registered voters of that particular county, Mr. Speaker. This takes away powers from the big boys of our political parties, but I feel it's a good provision. There have been, I know of stories, Mr. Speaker, and we've had petitions actually, including petitions brought to this this House, Mr. Speaker, where the only time a certain MCA was ever seen in a county assembly is the day when they went to take the oath of office. In fact, on the day of the swearing in, they were seen in certain towns asking for directions to the county assembly because they don't know even where the county assembly of that particular county is, yet they are members of a county assembly. So I want to urge members to support this so that political parties can only nominate voters from that particular county, Mr. Speaker. Clause 20 of the bill proposes to amend the Act by inserting new Section 38A to provide for designation of polling stations by IBC and publishing them in the Gazette at least 3 months before the date of any election. You know, we have argued before about creation of polling stations. Senator Eddie has a thing or two to say about this. Mr. Speaker, I read part of things he has said about against the IBC elsewhere. So we are making it now provided for in law, Eddie, that 3 months to the election, IBC must publish by Gazette notice the list of all the polling stations so that Kenyans know, they can check, and we don't have issues arising of saying, what was the name of that fellow? Jose Camargo created certain polling stations. Clause 22 of the bill proposes to repeal and replace Section 39, which provides for the determination and declaration of results and substitute it with a new section. The new section proposes that results at the polling station shall be final, and the presidential election shall be tallied, announced and declared, and electronically transmitted before all other elective positions. Further, the new section has omitted provisions providing for, 1, where there is a discrepancy between electronically transmitted and physically delivered results, the results, which is an accurate record of results tallied, verified, and declared at the respective station, shall prevail. B, any failure to transmit or publish election results in an electronic format shall not invalidate the results as announced and declared, because this is technology. Things happen, Mr. Speaker. Part C is a requirement for IEBC to establish a mechanism for live streaming of results as announced at the polling station to facilitate public information. Part of the public trust building mechanism, so that IEBC has part of its system, ways in which after the declaration of the presidential election result at Kapmaso Primary School in Kabianga Ward, where I vote, Mr. Speaker, I should be able to visibly check and confirm, because unless you have somebody who was at Kapmaso at the time of declaration of that result, Mr. Speaker, at Bomas, sometimes it's difficult to verify. Therefore, the easier thing to do is to make this information public so that I can easily check and confirm that if they announce that candidate X secured 400 votes, that is what is reflected on the IEBC portal. Clause 23 of the bill proposes to amend Section 44, which provides for technology to provide that the Commission shall ensure that the intellectual property to the technology is vested in the Commission. Senator Eddy should know why this forms part of that conversation. A supplier of the technology to be used shall not be found guilty of violating any procurement law or committed any crime anywhere in the world. Additionally, this is about open the server conversation, Mr. Speaker. And the 2017 one was the servers are asleep, Mr. Speaker, somewhere in France. This is part of addressing and providing clarity to that. Clause 24 of the bill proposes to amend Section 44, which provides for the complementary mechanism for identification of voters by inserting the words transmission of election results and mandating IBC to make regulations for better carrying into effect provisions of Section 44, part of what I had mentioned earlier. Clause 25 of the bill deletes Section 45, which provides for the conditions under which an MP may be recalled. These provisions were declared unconstitutional in the Katiba Institute and another versus the Constitution AG in the Constitution Petition number 209. Clause 26 proposes to delete the provisions of Section 46 1B, and that required the petition to recall a member of parliament must be signed by a petitioner who was registered to vote in the election in respect of which the recall is sought, and that the petition must be accompanied by an order of the High Court. These provisions were also declared unconstitutional, Mr. Speaker. Clause 28 proposes to repeal Section 74 of the Act, which provides for the settlement of certain electoral disputes by the IBC, since the mandate is now a function of the PPDT, Mr. Speaker, as provided in the Political Parties Act of 2011, Mr. Speaker, just providing clarity. 29 of the bill proposes to amend Section 75, which provides for the county election disputes by deleting the requirements that appeals to the High Court shall be on matters of law only, and inserting new Section 5 to provide that the decision of the High Court on appeal on the validity of the election of a member of a county assembly shall be final. Clause 30 proposes to amend Section 82 of the Act, which provides for the scrutiny of votes by providing that a court may extend a scrutiny of votes beyond the polling station or areas mentioned in the pleadings, Mr. Speaker. A rather obvious provision, but those who practice law in our courts like you, Mr. Speaker, know that this has been limited, actually the limitation of many election petitions, where perhaps given that election petitions are time-bound, Mr. Speaker, sometimes a lawyer either forgets sometimes a lawyer forgets, Mr. Speaker, to file in many of their contested election results, Mr. Speaker, and later on in the court process, they are denied the opportunity to provide for scrutiny, even when it becomes rather too obvious that an opening of a particular voting station, Mr. Speaker, will help the court in making the determination. Part 32, Mr. Speaker, Clause 32 of the bill provides to amend Section 85, which provides for appeals to the Court of Appeal in respect to members of the National Assembly, Senate, or the office of the county governor, by deleting the requirements that appeal shall be on matters of law only, and inserting a new subsection 5 to provide that the decision of the Court of Appeal shall be final. I'm sure Senior Counsel Okongo Mogeni, who shall be seconding this and was part of the NADCO process, shall expound more of this. Clause 33 of the bill proposes to insert new Section 87A, 87B, and 87C to provide for the appointment by Parliament of an independent firm to carry out an evaluation of the electoral process after a general election. The evaluation shall include the review of the legal framework, processes and costs associated with the electoral process, and propose new provisions require preparation of a report and submission to Parliament within 90 days of the appointment of the independent firm. Just to ensure, Mr. Speaker, that at the end of every election, Mr. Speaker, we provided for a firm to audit the process in its entirety and lead Parliament in passing legislation such as this. Senator Ledama, you are not in the House, but I mentioned earlier that mistrust is what we are trying to cure in many of these proposals that are here. Otherwise, in other parts of the world, many of the proposals that are here will appear like obvious things. And therefore, to clean up our processes, what the bill is proposing is that after every electoral cycle, IEBC procures the services of an independent audit firm to audit the entire process from start in the preparation of the election to election day to declaration of results, and lead Parliament, including the cost of what it costs the taxpayers, Mr. Speaker, to run that election, and finally submit a report to Parliament so that Parliament can make independent decisions, Mr. Speaker, of how to further clean up our electoral processes, Mr. Speaker, or review certain costs or certain decisions that we are provided for in law that make it extremely expensive to run our elections. Remember, our elections costs are legendary, Mr. Speaker, and we have mentioned why this. Finally, Mr. Speaker, is a clause 33, which I have actually explained that particular clause 33. Therefore, as I conclude, Mr. Speaker, I wish to state that this is a very important bill, and therefore I want to urge honorable senators to support it. This is about what brings you to this House and the people that you represent. Elections are extremely important because they are the tools which forms actually the chance for the citizen to speak and exercise Article 1 of our Constitution directly, Mr. Speaker. Therefore, we are duty-bound as Parliament to provide and make it possible for them to exercise that constitutional provision with a lot of clarity. Senator, with those very many remarks, Mr. Speaker, Senator Okongo Omogeni was part of the NADCO team at Bomas of Kenya. NADCO 2, actually. I know Senator Ledama was part of the first one, and therefore has a good understanding as well of this bill. Therefore, I want to grant him the opportunity, Mr. Speaker, to second this bill. I thank you.
Before the senior counsel seconds your bill, majority leader, I would want to give you the comfort that part of what you said in the process of moving your bill is an inquiry as to a return or an exit report from the observation that we had with the elections conducted just in the United States of America. And the issue is about the trust deficit, which that report will speak to. And it will answer a number of the concerns which we are trying to cure in this particular bill. I would like to give you the comfort that the team indeed represented the House in doing what it was sent to do. Senator Olekina has confirmed that he was in NADCO 1, where yours truly was also a member, and so we participated in this process leading to the NADCO 2, where now I would like to ask Okongo Omogeni to second the bill. Senior Counsel, Senator Okongo Omogeni.
Yes, thank you, Mr. Speaker, for giving me an opportunity to second this bill that has been moved by Senator for Kericho. Mr. Speaker, for the record, you know, I went to a school that is in a village where Senator Cheruiyot comes from, in Kabianga. So it's my pleasure to have served with him in NADCO. And Mr. Speaker, without the spirit of give and take, we will not have reached where we are today. So I want to thank him and the members that represented the UDA coalition for coming with a spirit of give and take. We did not get everything that we wanted as Azimio, and I'm sure that there are positions that were not representing the UDA coalition
but that they agree to accommodate in the spirit of give and take. And Mr. Speaker, the spirit in NADCO was to ensure that when we go to the next elections, Mr. Speaker, the person who wins the confidence of Kenyans, the person who garners the majority of votes, Mr. Speaker, does not face a contestation in the Supreme Court. We hope, Mr. Speaker, we'll reach a situation where we'll have the person losing an election conducting himself like Biden. I think in the USA last week, within 2 days, President Biden, who was not a candidate, but whose party, the Democratic Party, had lost an election, placed a call to President Trump, who had won through the Republican Party, and said in a democracy there must be a winner and a loser, and he was welcoming him to White House so that he can assist in managing the transition. So I hope, senators, that you will support these amendments to the elections laws, which is trying to make it easy, make it transparent, and make the path to declaration of a winner in a presidential election much easier and more transparent. In fact, Mr. Speaker, one of the issues that we really fought about was what is, I think, in clause, I think it's clause, in clause 39 of the bill. You know, Mr. Speaker, in the United States of America, you will start predicting the winner of a presidential election going by results coming from states. And Mr. Speaker, what this bill is proposing is that we now allow polling stations to have returning officers, so that if we are in Ikolomani, Mr. Speaker, by the time we are done with the counting and tallying of votes in that polling station, the returning officer will give final results and declare the winner from that polling station. So that by midnight, we should be getting results telling us, in Iborabu constituency, Boni Galwale, if he will be a candidate in 2027, I don't know whether he has presidential ambitions, it tells you Boni Galwale has taken Ikolomani. And if Senator Cheragei will be running for Gen Zs, we are told in Iborabu constituency, Senator Cheragei was number 3 or number 1. That is the spirit behind this proposed amendment, so that we don't need to wait for the commissioners in Nairobi to tell us who has won in Ikolomani. I mean, if in Iborabu, Mr. Speaker, we have tallied votes from all the polling stations, by the close of the day, we should see a 411 telling us that candidate A has taken Iborabu. By the time we wake up in the morning, we should be knowing from all our constituencies, 290 of them, who is leading in a particular constituency. That makes the voting, the counting, tallying of results more transparent than what we have now, where you wait for returning officers to walk all the way to Nairobi before IEBC can declare who is a winner. So this is a game changer, honorable senators, that even if you want to contest a presidential election, you can narrow down to the polling stations that are contested. You don't need to sue the chairman of IEBC. You can actually select the few polling stations which are contentious, and you move to court challenging results from those particular polling stations. Mr. Speaker, also because of the high stake in presidential elections, we are making it mandatory that the first election that should be counted and tallied is the presidential election results. So if we close the voting in a polling station, Mr. Speaker, the first seat that should have votes counted is the seat of the president. Once it's done, you move to the county governor, senator, member of National Assembly, women, count women rep, and then you finish with MCA in that order. That's what we are proposing in this bill. It's all in the spirit of making it transparent so that we adopt the system that we see in the US, where by midnight you'll be told Trump or Harris has carried Florida. That becomes the end. Next, you will be told Texas has gone to candidate X. And then the second thing, Mr. Speaker, is to adopt technology. What makes the results to trickle in as quickly as we saw in the US is because they are using technology, Mr. Speaker. If you employ technology, you get your results faster. I don't know what is the experience of honorable senators here, but in my seat, Senate Nyamira, I waited for 2 nights. 2, Mr. Speaker. Because people are doing manual counting, you wait for 2 nights. And if you are not sure about your victory, you don't even break to go and have a meal. You can't even go and have a bath. But if we embrace technology, we can do our tallying much faster, you know, and we get our results almost the following day. Why should we vote on a Tuesday and you're being declared on a Thursday? That waiting is too long. So I hope when we get new commissioners in IBC, they will bring in technology that brings really change. In Brazil, you conclude elections and in the next 3 years, Senator Chiragei went to Brazil, I think, in the company of Governor Mutula, who was then Senator, Senior Counsel James Orengo, and they saw real time. But the problem in this country is that once people get positions, like you become a commissioner in IBC, you think more of how you are going to make money from that technology, instead of looking at bringing in a technology that will make the running of elections more efficient. If Brazil can use technology and declare elections within 3 hours, why not Kenya? Are we cursed? Mr. Speaker, are we a cursed country? I mean, and we use more money. If you follow, you'll find that we are paying more money for that technology than those other countries. And I've had Senator Sige telling me that even in the US, it took few hours. I think within 2 hours after the close of elections, results were trickling in. Really, we need, Mr. Speaker, when we get a chance to vet the new commissioners to IEBC, we should vet and ensure that the people who are getting a chance to serve in that commission are men and women of integrity, who can put public interest ahead of selfish interest of wanting to enrich themselves, Mr. Speaker. We don't want to hear those scandals we read some times ago about IEBC. Mr. Speaker, I want to fully support the proposed amendment that makes nomination of members of county assemblies, as proposed in clause 19, to be people who are registered in those wards. The Speaker, the only thing we did not agree, and I hope we can find agreement, is that this should also be extended to our constituencies and our counties. If you are being nominated to represent a constituency in Starehe, Nairobi, you should ordinarily be a member who votes in that constituency, Senator Mutinda. If you are being nominated from West Mogirango in Nyamira, you should be somebody registered in that constituency. I've had agitation. Yesterday I was confronted by Senator Asige here, pitching that nominated senators should have money for county operation offices. If you need that money, Mr. Speaker, we should ensure that you come from that county. Because if you get money to run your office, it should be Senator Mutinda, Nairobi, running our office in Nairobi. Senator Asige from Mombasa, running our office in Mombasa. Senator Beatrice Oyomo from county of Homa Bay, having an office in Homa Bay, running our county office in Homa Bay. Ordinarily, you should be somebody who votes in that county or in that constituency or in that ward. So I'll be maybe asking senators, honorable senators, to reconsider whether clause 13 should be extended so that we don't just say MCA voting in that ward. Let us extend that spirit, that intent to be applicable also in constituencies and in our counties. I think it's a fair thing to do. The other point I want to make to contribute on, Mr. Speaker, is the issue of appointing polling stations, as proposed in clause 20, which is amending section 38A. Mr. Speaker, I was privileged in 2017 to be one of the lawyers who was appearing for Honorable Raila Amolo Odinga in a presidential election petition. And you know, Mr. Speaker, some of the issues that cropped up in that election petition is a situation where returning officers would tell us that I decided to set up a polling station in a certain place because nomads had moved. There were no people in the designated polling station. I mean, we can't do that. Polling station should be known by voters. So what this amendment to section 38 is proposing is that IBC must appoint a place that is publicized and that is known to the voters. So if we're in Nairobi and you say polling station is Stare, and for example, that should be what the voters in that constituency know, and that's where they should go and vote. If you are in West Mogrango and you say one of the polling stations is Girigiri Primary School, that should be gazetted, publicized, and known to the voters. We should not have a situation where capriciously Electoral Commission officials can set up polling stations that are not known to anybody. 3, Mr. Speaker, as you know, you practice as a lawyer, and we have had serious problems with time. If you are doing a presidential election petition, Senator Cherage, you know the time within which you must sit, sift through cartons of documents, prepare your petition, and file. And then when you appear before the Supreme Court, they will tell you, you cannot do scrutiny in polling stations that you did not name in your presidential election petition. Lawyers are also human beings, Mr. Speaker. We are not machines. So we are giving leeway to the election petition courts to look at issue of allowing scrutiny in polling stations beyond the time that is given, so that you don't need to restrict a council and say, if you didn't name your polling stations where you need scrutiny within 7 days, we will not allow you. We want to give our judges an opportunity to hear lawyers, exercise judicial discretion, and if they think a basis has been laid, then they can extend time and allow scrutiny. The spirit of Article 159 of our Constitution is to do substantive justice and not pay undue regard to technicalities of procedure. I know those who practice law in this House, like you, Mr. Speaker, you understand how important this particular amendment will be to lawyers. Then they proposed amendments to Section 82, access to information, including technology used in an election. You know, we are trying to cure the problems that we all saw during the election petition that was filed ensuing from the 2022 general election. In 2017, Mr. Speaker, if you remember, the Supreme Court issued an order for that technology to be released. We were told the lawyers in France had not woken up. When the lawyers in France woke up, we were told the technology is also hosted in USA. The lawyers in USA were asleep. We waited till 8 p.m., which is in the US was about midday. Still, technology was not availed. So we are making a proposal here, Mr. Speaker, that the Commission should ensure that there is access of information, including any technology that is used in an election. Because, Mr. Speaker, this is public money. When we are employing technology, we are using taxpayers' money, Mr. Speaker. And we want Kenyans to have easy access to information so that everything is transparent. The spirit in Articles 80, 81, 82 is that our elections should be transparent, they should be very viable. There is no way an election can be very viable if we are not making technology available. That is in the spirit of making Kenyans to have faith and confidence in an electoral process. It was our prayer in NADICO, Mr. Speaker, that in 2027 elections, we should not have a dispute. Everything should be so transparent that at the time we conclude the elections and a candidate is declared, every Kenyan should accept that truly that is the choice of the people. The other problem, Mr. Speaker, and I'm sure most of us who are candidates have experienced, is the issue of delay, which is being addressed in clause 39. The proposal there is that each polling station should have a returning officer, and once you tally the votes, you make a declaration. But there has been a problem before. You know that you can have a polling station that is the closest to the constituency tallying center. But there can be delay, unreasonable delay, in releasing results. You finish counting even at 8 p.m., but the presiding officer will tell you, I'm not able to announce results till the following day. What we are proposing here, Mr. Speaker, if you read clause 4, we are saying that the results should be tallied within 2 hours. Within 2 hours, results should be released, everything fed into the electronic system, and everybody has access to the results. And if you delay, there should be consequences. If you unreasonably delay announcement of results, there should be consequences. In 2013, I did an election petition for a candidate in an election in Nyaribari Church. And Mr. Speaker, while we were looking through the transmission of results to the tallying center at Gusii, we discovered that the polling station that was closest to the tallying center was the last one to declare and transmit results, Mr. Speaker. And when we requested the court and the court ordered scrutiny, Mr. Speaker, we found that there was a lot of tampering of results from that polling station. So at times, presiding officers delay release of results deliberately so that they can manipulate the results, interfere with certain documents, okay, before the results are announced. So this idea of giving the presiding officers and the returning officers time is to ensure that there is no opportunity given to the presiding officer or to the returning officers to manipulate the outcome. As I conclude, Mr. Speaker, I know we have not prescribed in these amendments that IEBC should assist political parties in carrying nomination. But, Mr. Speaker, I think time has come for political parties to allow IEBC to conduct nominations for parties. There are many regions in this country, Mr. Speaker, where nomination means everything. If you win, you are as good as a member of parliament. Lawyers will tell you, including Cheragei and yourself, that Law Society of Kenya conducts its elections using IEBC. It's not prescribed in any law. But because they want transparency, they want to build confidence in that process, they have invited IEBC to preside over and conduct elections on behalf of Law Society of Kenya. Why can't my party, the largest party I believe in Kenya, ODM, why can't ODM allow IBC to conduct its nominations? Why can't UDA allow IEBC to conduct its election? In fact, in the same spirit, Mr. Speaker, all other bodies, public bodies, including KOTU, headed by my friend Atwoli, they should allow IEBC to assist in running or in conducting of elections for officials of those bodies. If Atwoli is a popular person, why should it be that you go to Tom Mboya and people come and shout and then you become the Secretary General? Allow IEBC to set up mechanisms in all counties, Mr. Speaker. And our Mzee Atwoli, who is very popular within the labor movement, will be elected in elections that enjoy the confidence of the workers of Kenya and any other person. So, Mr. Speaker, I urge my colleague senators to kindly support this elections amendment bill that was developed through a bipartisan spirit with the majority side and the minority side that is trying to do a cleanup in our electoral process and to ensure that as we gear towards 2027 elections, we create a legal regime that will have transparent, verifiable, and uncontested elections. With those remarks, Mr. Speaker, I second.
Now, Senator Senior Counsel Okongo Mogeni, in your reference to the political parties, you made reference to one party you called UDA. The name they prefer is the UDA, United Democratic, not UDA, but UDA. Now, Honorable Senators, I propose the question that the Elections Amendment number 2, Bill, Senate Bills number 29 of 2024 be now read a second time. I will invite members who are keen to contribute to this particular bill to make their contributions, and I'll ask the Honorable Senator from Nandi, Samson Cherargei, to proceed to make his contributions to the bill.
Thank you, Mr. Speaker, sir. I have listened keenly to the members of NADCO move ably the bill, although, Mr. Speaker, if you remember, you denied me the right to appear before the NADCO committee, but I'm happy that I have now opportunity to have my views being heard in a neutral environment, because, Mr. Speaker, I remember maybe that opportunity was politically corrected, guided, unlike what we are doing here, Mr. Speaker. So, and I'm happy the Parliamentary Service Commission commissioner has moved ably, the majority leader, and of course at one point you sat also as a member of NADCO committee, Mr. Speaker, and therefore I'm happy the Parliamentary Service Commissioner, who is a senior counsel, is here today in the evening, Mr. Speaker. I don't know whether he's aware that catering services are supposed to be outsourced, where food of members of parliament will be brought. We don't know the security, and I'm told the person who is pushing outsource of catering services is one of the members in Parliamentary Service Commission. And we are watching keenly. We shall oppose such a move because we are the employees. Now that you have mentioned Francis Atwoli as a popular unionist, we might need the services of Francis Atwoli in this parliament. You cannot outsource our food or catering services to individuals who want to use us as a guinea pigs in giving things, Mr. Speaker. So, Mr. Speaker, that was just on a lighter note for the, you know, it's rare to have commission of PSC in the House, but now that we have, you should know. Mr. Speaker, number 2, the cost of elections in this country, Mr. Speaker.
Senator Cherargei, there is an intervention from Senior Counsel. He wants to inform you. Are you ready to be informed?
I can be informed.
Very well, Senator Omogeni, proceed.
Yes, just to inform Senator Cherargei, my good friend, that I'm not aware of the alleged outsourcing of catering services by a Parliamentary Service Commission, and to also make it clear to the people of Nyamira who may be watching that I'm certainly not one of those commissioners who are pushing for the outsourcing of catering services.
So are you, Senator Omongen, are you saying that there is a push at the same time you're not one of them?
I'm hearing it from Senator Cherargei. He seems to be highly connected to PIC commissioners. I saw him enjoying a cup of tea prepared by our staff, and I thought the food we serve is delicious and very tasty for our members. So I'm absolutely not aware. I just want that to be on record. And if there was such a push, certainly Senator of Nyamira, Commissioner representing Senate, is not one of the members pushing the outsourcing of catering services, Mr. Speaker, for members of Parliament. I just wanted that to be on record.
That information was meant to be to you, but will also affect the entire membership of this House, Senator Cherargei. Proceed.
Thank you, Mr. Speaker. What I want to confirm is it is the highest level, Mr. Speaker. Maybe the Commissioner, Senator Okongo Mugeni, Senior Counsel, Mr. Speaker, should be informed, and I hope they will not allow that to happen, because we will resist any such move. Mr. Speaker, secondly, Mr. Speaker, I'm informed that the American ambassador, Megan Whitman, has resigned. I want to pass our deepest appreciation for her tour of duty in the country and for being supportive to government, Mr. Speaker. You remember under her tenure, the Kenyan government was able to work closely with the Haiti government to bring peace and security. Mr. Speaker, and also he organized, Mr. Speaker, Ambassador Megan Whitman, the U.S. State
Senator
visit.
Cherargei,
yes.
I want you to confine your contributions to what yesterday you were reminded by the Honorable Senator Boni about the relevance of your comments to the motion at hand.
But you know, Mr. Speaker, U.S. is one of the biggest donors to elections in this country. She was very instrumental. She was among the people who are in bombers with you. I'm surprised. You should be appreciated.
As you do that, let it be
I'm tying up because, Mr. Speaker,
this particular bill.
Yes, I'm tying up with what is happening, the NADCO, the genesis of NADCO. You know, the embassies and the government, U.S. is one of the heaviest funders, not only to peace and security, but to elections in this country. And she was very supportive, and we wish her well in a tour of duty. Secondly, Mr. Speaker, you have to appreciate the cost of election is very expensive. Last year, and that has been my argument, Mr. Speaker, the last election of 2022, Kenya spent a whooping 35.8 billion Kenya shillings. That translates to 2,000 shillings, Mr. Speaker, per voter, which is very expensive across the world. 2,000 per voter, which is too high, Mr. Speaker. Therefore, Mr. Speaker, we must agree that the election business in Kenya should not be live and dead. You are in the U.S., you saw people voting by mail. You saw people accepting results graciously. And I'm happy in the U.S., Mr. Speaker, and I heard my brother Senator talking about Biden inviting Donald Trump to the White House. Was it today? Or today? And therefore, we want peaceful transition where people go into an election, contest, you lose fairly, you accept. I think what is happening, Mr. Speaker, and you have noted in some of your comments, that there is deficit of trust among African countries and more so Kenyans. We don't trust each other. I think the only time Kenyans will trust each other about elections is when Jesus Christ is the returning officer. Because the fact we are becoming too prescriptive on election laws in this country. We are becoming too subjective to the election laws in this country. We are prescribing even how a returning officer should sign the declaration form at the polling station, at the county tallying center, at the national tallying center, Mr. Speaker. We are aware of how we don't have trust. It happened in 2007, 2008, Mr. Speaker. The tampering of elections, the problem in this country is lack of deficit to the institutions we have. People don't even trust Parliament. They don't trust judiciary. They don't trust executive, Mr. Speaker. And therefore, it behooves to us that the institutions that the Constitution have built, we should trust, Mr. Speaker. And that is why the cost of election is very high in this country. Even as we talk, Mr. Speaker, as of today, the pending bill that IEBC has that has not paid their people, the matatus, the people that provided service and goods, stands at whooping over 2.05 billion Kenya shillings, Mr. Speaker. While I agree, Mr. Speaker, with a number of, I think this proposal is just a cleanup of the Elections Act, because having served as the chair of JLAG in the last session, Mr. Speaker, we did a number of amendments, elections, push and pull between the National Assembly and the Senate. Mr. Speaker, outside the basic laws on basic issues Kenyans affect, the highest legislated matter in this House and in this country is the issue of elections. We go to an election, we notice a problem, we come back and legislate. The other day, we didn't trust the ICT, the IT to use of technology in elections. Now we want to trust it. The other time we were told there was Jose Carmago somewhere. The other time we were being told the satellites servers are in France, and you remember the famous word Fungua server. Mr. Speaker, others were saying it is in the US. There is time difference, Mr. Speaker. And I think it is important that we need to agree. I'm happy in one of the Section 2 of the Elections Act, we have amended to include ID as identification as Kenyan passport, which is good, and the registration of candidate. I think those are cleaner. Mr. Speaker, on clause number 3A is suspended. I agree that during by-election or during referendum, somebody who is not a voter or who has not registered that time during referendum and by-election, the registration and opening and inspection of voters' registers should be suspended until the by-election and referendum is done. And, Mr. Speaker, I agree. I think in Mutula Kilonso's case, when he passed on, the victim of such was the sister to the current governor of Makwiny, since she was not registered as a voter. So it is now better that if a by-election is happening in Vihiga or in Banisa, for example, if I come from Banisa but I vote in Nairobi, the law should not allow me to participate in election of Banisa. And I agree with this provision, so that we don't have ambulance chasers for elect parliamentary seat. You remember the famous political ambulance chaser is one Babayao Ferdinand Waititu, where he was contesting in Embakasi, when unfortunately the former MP was killed, that used to come from Kiambu, who used to work as a unionist. He left here and went and contested. When it came an opportunity of becoming the governor of Kiambu, he left here and went to contest. So this provision will cut lane. In fact, Governor Sonko was also trying to be an expert, where he was now, after failing to run here, he wanted to run in Mombasa. Yet I am sure that he was a voter in this city. So we need to ensure that even people like Senator Kalwale would want to run for governor. We don't want somebody who is running in Nairobi as an MP decides to wake up one day and run for governor in Kakamega, yet those people don't know who you are. So let us bring sanity and hygiene in our politics, Mr. Speaker. On the issue of Section 6, elections before the date of election, I agree, within 60 days is sufficient to rectify your particulars as a voter and also to give you a chance. Even in by-election, like now what is happening in Banisa, there is a ward in Kakamega that has similar challenges after the MCA was killed. The issue of referendum, I agree that 60 days is sufficient period to rectify your particulars as a voter in that region, Mr. Speaker. Mr. Speaker, the fourth point that I wanted to make is in Section 27. Mr. Speaker, within a coalition political party, for example, Azimio, I remember, Mr. Speaker, before we went to elections of 2022, some of us who served in the 10th session, we were being pushed. I remember Otsotsi was in the National Assembly, the Lower House. Mr. Speaker, we were being pushed to amend to create what we call coalition political party. Mr. Speaker, and the proponents then were in power, and they came up with something called Azimio coalition. And I'm happy when it came to the new session, the definition of coalition party became a challenge. And we are now where we are in the beginning, because now with the broad base, those things are no longer relevant. Mr. Speaker, and I think when a coalition agreement should be submitted, a copy, to register political parties. Mr. Speaker, are you aware, in the last session, it is only Kenya Kwanza coalition agreement that was given to register political parties that was made public. No one made public the Azimio coalition agreement up to today, unless there is contrary information outside there. So we want everybody to be equal before the law, Mr. Speaker. No, you know, Mr. Speaker, Senator Otsosi was in the lower house. He could not have been aware of what was happening. Mr. Speaker, Now he's in the upper house. He can know what is happening. I'm just informing.
Senator Osotsi, you know how to catch the eye of the
Yes,
Speaker.
the
Senator
Speaker.
Cherargei, proceed.
As a deputy party leader of ODM and a senior member of broad-based government, he should hold resources, Mr. Speaker. So, Mr. Speaker, what we are advising is to clean up, Mr. Speaker, and ensure, Mr. Speaker, that it is delivered. Mr. Speaker, Senator Osotsi would have allowed me to quickly finish so that when he's contributing and can make his comments. Mr. Speaker, in section 34, I agree. Mr. Speaker, can you believe you get an MCA in Wajir, but he was nominated from Nairobi? He doesn't know even where Wajir County is or County Assembly. You get in Kericho, in Vihiga. These political slakings and slakings must be stopped, Mr. Speaker. I agree. We cannot let us nominate women, people living with disability that come from that ward, from Kisumu, Mr. Speaker. From Awendo, Papa Udit, let that be registered there, Mr. Speaker. We don't want people who smile before the political party leaders and they are being vetted in hotel rooms to have opportunity, Mr. Speaker. Mr. Speaker, we are aware of political party leaders who vet people in the hotel rooms and going
Senator
to Santorini, Mr. Speaker, to get opportunity to be nominated, Mr. Speaker.
Senator Osotsi, what's your point of order?
Mr. Speaker, is it right for my friend Senator Cherargei to claim that it is bad for people to smile before party leaders? Does it imply that people are supposed to cry before the party leaders?
Senator Cherargei, that particular point of order insinuating on the part of the leaders of political parties is not the proper language to utilize in the House.
Mr. Speaker, let me rephrase, Mr. Speaker, that some people, some individuals, it is good to smile to political party leaders, it is good to get angry at them, but I'm saying some political party leaders, and you know the guilty are always afraid, Mr. Speaker, the Bible says what? Some political party leaders are known to vet the nominees, Mr. Speaker, in hotel rooms and in Santorini, Mr. Speaker. We are aware, Mr. Speaker.
What's your point of order,
I'm saying some, Mr. Speaker. I'm using the word some.
Take your seat. There is a point of order from Senator
Just before that statement, is it right for the senior ranking member, the Senator of Nandi, to insinuate that it is only women and people living with disability that can be nominated? As it is today, the current CS of Finance has been a nominee from the National Assembly, and that was a man. So it is not only women that are nominated. Even in this House, we have Senator Chimera, we have Senator Mbogo, and they are not women. And, Honorable Speaker, some of us, like me, is nominated. You cannot say I got my nomination through a smile. I'm beyond a smile, Honorable Speaker.
Senator Cherargei, the chair directs that you confine your contributions, check your language, and withdraw the statement that make reference
Mr.
to
Speaker,
members having been vetted in hotel rooms. That is not
Mr.
parliamentary.
Speaker, I've said some...
And confine your contributions to proper language. Senator Cherargei, that is the directions from the chair. I'm warning you so that you do what is right as a ranking member of this House.
Okay, Mr. Speaker, can I rephrase? I've said some political party leaders. I didn't say all, Mr. Speaker. And number two, I've said, Mr. Speaker, I have been in politics long enough to know some of these things, Mr. Speaker. I might be young, but I know so many things that many people don't know. And Mr. Speaker, I want to rectify, anybody can be nominated by political parties to serve as senators, members of parliament, and I agree with the information by my Senator Ogola. If you know you are nominated by merit, why worry? Mr. Speaker, I'm saying, I'm calling out political party leaders who are political briefcase parties, that when they get chance to nominate, they go for other conditions, which my learned senior and law lecturer smiles and knows, because I have shared with him, Mr. Speaker. Finally, Mr. Speaker, because my time is spent.
Honorable members, order. Allow Senator Cherargei to conclude.
Let me conclude. I have abandoned long time ago my sister. The commission shall appoint a place on the issue of presidential declaration of results, Mr. Speaker. I agree the chairman of IEBC should have opportunity to declare the president-elect, Mr. Speaker.
Order,
because,
Senator
Mr. Speaker, we don't want to go, Mr. Speaker, where the Cherera 4 tried to do. I agree that the person who should declare the president-elect and deputy president-elect should be the chairman of IEBC. We don't want to go to Cherera 4 debacle, which almost brought this country to instability, Mr. Speaker. So I agree with your wisdom that you did bring that at least, Mr. Speaker, the IEBC chairperson should declare the president-elect and deputy president-elect. On the issue of electronically transmitting results, we are in the era of technology. 2 hours is enough. Let us know, Mr. Speaker, if we are not careful with the current Gen Z with technology, we can always know who is winning or who is not winning. So I agree on the issue of electronic publishing of results. We are tired, you know, CROs and county can be hijacked as they come through Kericho somewhere in Awasi, and they can disappear with the results, Mr. Speaker. Mr. Speaker, on the issue of auditing, Mr. Speaker, on the issue of auditing, I agree after 1 year we should audit. I agree that your committee, JLAC, should give us what was the outcome of presidential and national elections within 1 year. That should be sufficient to give us audit, Mr. Speaker. This is a very good legislation. One thing I'm happy, Mr. Speaker, you remember in conclusion, there are a number of MCAs who have been complaining that they were not given chance, Mr. Speaker. We need to rectify on the issues that are within elections. Let this country have trust in our institutions, Mr. Speaker. I agree, Mr. Speaker, with your senior colleague who said that even nominations should be done by IEBC, Mr. Speaker. Some of the people, some of good leaders have been lost. Can I get 30 seconds, Mr. Speaker? Some of the people have lost their seats because of bungled nominations, Mr. Speaker. Many people who have seen nominations will tell you it's not an easy process. And where you come from sometimes, Mr. Speaker, I will make my position known during voting. I thank you.
I now call upon Senator Sotsi to contribute.
Thank you, Mr. Speaker, for the opportunity to also make my contribution on this very important bill, the Election Amendments Bill 2024, that is a product of the NADICO process. And I'm happy that this House has already dispensed with the Political Parties Act that is now supposed to go to Committee of the whole House. And now we are handling the Election Amendments Bill. Mr. Speaker, I want to support the provisions in this bill, although a few others I have reservations. And let me start by looking at clause 3, which talks about the people who register as voters during the by-election process should ideally not be eligible to contest election in that electoral area. You remember we had the long-drawn case of Keith Kilonzo, which many people are questioning why she was not able to contest. But I think it's important that during that period, people who are keen to be candidates should be stopped. Because why at the last minute, Mr. Speaker? So I think that's a very progressive amendment, and I support it. Mr. Speaker, I also want to support Honorable Cheregei's statement that election in this country is very expensive. We conduct a very, very expensive election process. And I think the issue of cost of conducting an election in this country must be looked at, so that we don't make election very expensive and therefore make other very important national programs derail because of election. Mr. Speaker, let me also comment on what is happening now, Mr. Speaker, where we don't have IEBC. It is a pity that this country does not have an IEBC, Mr. Speaker. This is a very risky IEBC commission. what we have is an IBC secretariat. We don't have an IBC commission. It is important that the courts also have to take judicial notice of what is happening in the country. Because without an IBC, Mr. Speaker, we run the risk, major risk, constitutional risk in this country. I am surprised that even a mere decision of coming up with a selection committee, people who will serve maybe for 3 months, it has dragged in court, and even after the court made a decision on that, some other people rushed to court. Why is the courts entertaining all this? They need to take judicial notice of what is happening to the country. They need to take judicial notice of the fact that unavailability of IBC is a serious problem, a serious risk that can lead to a constitutional crisis. So I think it's important for us to have an IBC so that the by-election, the people of Banisa, the people of several electoral areas who do not have representative, they can have representative in those areas, Mr. Speaker. Some are even not able to get services because they don't have either an MCA or a member of parliament. Going back to the bill, Mr. Speaker, on clause number 18, which is seeking to amend section 33 of the Act, the issue of gazettement of names of political party candidates and independent candidates to contest in an election. I think this is important so that these candidates are properly gazetted, and even the independent candidates are properly gazetted before an election. Also, Mr. Speaker, the amendment to clause section 34, which are contained in clause 19, which talks about the people nominated must be natives of those counties. I think this is important because we have seen scenarios where people come from other counties and are nominated in another county. That effectively discriminates against the locals of that area. For example, if you bring, I know some time back we had in my county someone from Kisii County who was nominated in Vihiga County. I know in Bonhalwale's county, Kakamega, we had someone from Northeastern and Siaya who were nominated in Kakamega. Mr. Speaker, this amendment will heal that. And also the requirement that in nominating candidates, we must take into account the wards, the balance of wards in that county, so that we don't have all nominated slots going to a few wards and you find the other wards being left out, Mr. Speaker. So that is a very progressive amendment and I support it. Mr. Speaker, on clause 20 of this bill, which is seeking to amend section 38 of the Act, that provides that that the polling station shall be gazetted at least 3 months before the date of an election. Mr. Speaker, this is very important so that we don't have a scenario where we have late gazettement of polling station that creates confusion, and also we do not have scenarios where during court processes we were told that some ungazetted polling stations were involved in the election. So this is very clear, Mr. Speaker, that at least 3 months before the general election, we must gazette all the polling station in a particular electoral area. If you look at clause 22, which is seeking to amend section 39 of the Act to state categorically that the Commission shall determine, declare, publish the results of an election immediately after the close of the polling station, and the results declared at the polling station shall be final. Mr. Speaker, this is a very progressive amendment, and it is important that we also have transparency in those polling stations. so that we have an election observers, we have political party agents, and all the people who are supposed to verify. And Mr. Speaker, going back to the issue of agents, you know, Kenya is among the few countries which are very innovative in very strange ways. You know, if the electoral agency is performing its role very well and doing its work very well and transparently in an accountable manner, then there should not be any burden on candidates to have agents in polling stations. It should be the role of the Electoral Commission. But this idea of having agents in polling station to verify the results is a clear confirmation that our electoral system has something wrong. And that clearly puts a lot of pressure on candidates. You can imagine if you are a presidential candidate in this country with about 45,000 polling stations, putting like 2 people in each polling station, that's already 90,000 people manning your results. And you are paying each maybe 5,000 shillings. Mr. Speaker, even before you do put your name on the ballot, you should already have a budget of 500 million shillings just to manage agents. Mr. Speaker, that is ridiculous. That is undemocratic. So we need to reform our IBC such that there is no pressure for candidates to have agents in the polling station, because the whole process is transparent, the whole process has clarity, and the whole process is protected by a functional commission. Mr. Speaker, I am also concerned about the amendment in section 39, subsection 6, the one that Senator Cheregei was referring to. The chairperson of the commission shall declare the results of the election of the president in accordance with Article 138(10) of the Constitution. Mr. Speaker, this is where we have a problem. And this is one amendment, one area that I will be seeking amendments. The problem with the Cherera 4 was that they were complaining that they were not involved in final verification and review of the results before they were declared. Mr. Speaker, I think this provision must be enhanced further to say that the commissioners will be involved fully before the chairperson of the commission declares the results, so that we don't have a scenario where some commissioners walk out and say that they were not involved in final tallying verification of the results. Mr. Speaker, clause 23, which seeks to amend section 44 of the Principal Act that talks about matters of procurement of technology, in this case IT technology. The issue of intellectual property rights to the technology will be vested in the commission. Mr. Speaker, this is very important. This is very important because, you know, during the election, the IBC cited in court that they could not allow access to its technology because the technology is intellectual property of the provider of the technology. And therefore, this can be an avenue to deny access to very important information by Kenyans who would wish to access that information. So this particular amendment is very progressive. Further to it, the supplier of the, or the associate of this supplier must not be people who are facing issues in their own jurisdiction, like they are guilty of violating the procurement laws, or they have committed a crime, or they have been involved in election malpractices in other countries. This section 44 that has been amended provides for that as well, Mr. Speaker. Mr. Speaker, clause 25 which seeks to delete Section 45 of the Principal Act. This Principal Act section, Mr. Speaker, talks about the conditions for recall by the public of members of parliament. Mr. Speaker, the current act makes it so difficult to recall a member of parliament. And this was put there deliberately by members of parliament trying to safeguard and beat around corners on the issue of recall. This section has now been removed, Mr. Speaker. So it is going to be very easy to recall a member of parliament, Mr. Speaker, including myself, if I'm not performing. Mr. Speaker, it goes on under Section 46, which has also been repealed to deal with all the conditions of recall under Section 45 and 46. Mr. Speaker, Section 28, no, Clause 28, seeks to repeal Section 74 of the Act to provide that disputes due to the nation will be the mandate of political parties tribunal and not IBC. During the election, Mr. Speaker, you have seen that on one hand, the tribunal is dealing with matters of dispute in political parties. On the other hand, IBC is doing the same. That is not the work of IBC. This amendment will ensure that only political parties tribunal will handle disputes between a candidate and his party or between political parties and not IBC. IBC role is misplaced, and that amendment heals that. Clause 29, Mr. Speaker, and amends Section 75 to provide that the election petition will terminate at the High Court for county assemblies. We should not have a scenario where the election petition for a county assembly member is taken all the way to Supreme Court. This law now provides that the case will terminate at the High Court. And the same applies, Mr. Speaker, to the Section 85A, which is amended under Clause 32, to provide that the petition for members of parliament, senators, and governors will terminate at the Court of Appeal, so that the Supreme Court performs the role that the drafters of the Constitution envisaged to do, specific things, and not dealing with the election matters. Mr. Speaker, if you look at Clause 31, also, which amends Section 82 of the Principal Act, it also provides that access to information. That access to information upon a request to IBC shall be granted within 3 days for presidential election and 7 days for other position. I think for presidential election, because of the limited time, because it has to be done within a limited time. 3 days is a long period of time. I think this should be reduced to 1 day, Mr. Speaker, considering the time constraint in presidential election. Mr. Speaker, Clause 32 seeks to amend Section 85A of the Principal Act on the issue of decision of the court on petition for members of parliament. I had said that. And Mr. Speaker, Clause 33 amends Section 87 to provide for the setting up of an independent firm approved by Parliament to do evaluation of election, and a host of things will be done here, including reviewing the legal framework, reviewing the register of voters, reviewing the role of the media, reviewing the voter counting procedures. A host of things will be done, and that has to be done within 1 year after the election. Mr. Speaker, that is very progressive amendment, which will basically cure a lot of challenges we are going through, Mr. Speaker. Mr. Speaker, election is so important And I hope that this bill will help us deal with the electoral challenges we have been having in this country, Mr. Speaker. Mr. Speaker, I go back to the issue of IBC. IBC, and I want to address the courts. Please, you have every right to receive cases, to process cases, but also listen to what is happening outside the courts. The judicial notice of what is happening outside the courts. This country will be in a crisis if there will be need to have an IBC, and there is no IBC. We will have a major constitutional crisis. So I want to call upon the courts to help us to expedite the setting up of a selection committee so that we can appoint the new commissioners who can now conduct by-elections, who can also prepare. We are now just about 2 years and a few months to the next general election, and we don't have an IBC in place. And you remember Kriegler's report said that all preparations to the election must be completed at least 2 years before election. We don't even have an IBC. So we have not even started, Mr. Speaker. So this is a very serious problem, and also the matter of cost of election, which must also be looked at, and also matter of transparency in our election, Mr. Speaker. Mr. Speaker, I want to say that I will support this bill, except for the matter of declaration of the results by IBC chairperson. I believe that if we want to heal the problem of Cherera 4, we must insist that the declaration of results by IBC chairperson must be after concurrency with the other commissioners, Mr. Speaker.
Thank you. Senator Boni Khalwale.
Thank you, Mr. Speaker. Mr. Speaker, I want to strongly support this bill, but with little tweaks here and there. And Mr. Speaker, I'm surprised that Senator Cherera and Senator Osoti, members of this House, who I believe are seasoned and they give serious thought to legislation, are complaining that our elections are too expensive. If you think democracy is expensive, please go and try dictatorship. Please go and try military rule. You will know the difference. And Mr. Speaker, I say this with maximum respect because I know for Cherera in 2007, when the country went bust because of flaws in electoral process, probably he was in kindergarten, so he has no idea how even, Mr. Speaker, sir, your own father, who was a senior member of this House, how they fought so hard to keep the country together. Mr. Speaker, I therefore want to say that our process that looks expensive, it is because we are ahead of many other countries in the world. They'll play catch up and they will start doing what we are doing today. I therefore want to thank the members of NATCO for this particular process that informed this bill. Mr. Speaker, I believe strongly that election laws should be reviewed regularly as a practice at the end of every electoral cycle. What is important in this belief of mine is that obviously there are lessons that we learn from every election that invite an opportunity for us to make the process better. We should therefore not ever get tired of reviewing our election laws over and over again. Mr. Speaker, it is agreed that an election starts and must end at a polling station. This was not only the intention of the Constitution, but it was also confirmed by the decision of the High Court, which has guided many, many petitions in this country that we have seen, especially the presidential elections. I therefore want to add my voice to this law that is now making it clearer that election will start and end at a polling station. Colleagues, let me tell you about the figure 500. If you are to take account of 1 up to 500, and you are counting pieces of paper, 1, 2, 3, up to 500, it cannot take an hour. It is within that 1 hour, you can sort out the votes. Abdul, senator, got this, his opponent got this, and then be able to count 1 to 500 and actually be able to get a result in a polling station of what the senator of Wajir got vis-a-vis his opponent. We should defeat the corruption that accompanies the voting process that leads to the delay in a place like Kisumu. The distinguished professor had to wait for 3 days before he could know his fate. What annoys is that, Mr. Speaker, in my own experience, I have got my own tallying center, counting and tallying center. I know the results because I get feedback from my counting agents in every polling station. Then I'm forced, after knowing the results by around midnight, I'm forced to stay 3 days for what I know to be announced by the returning officer. We should make this the practice, and I'm happy that they have now put in timelines that within 2 hours the results should be announced. Mr. Speaker, the reason why we should insist further is that the people who want to manipulate the electoral process usually count on our agents, counting agents, and our agents at polling station becoming fatigued. Because how will somebody sit in the counting hall, tallying hall, for 3 days, non-stop, and you expect them to be alert enough to guard against rigging? Mr. Speaker, I wanted to speak at length on this issue, but because of the request from the distinguished senator of Nairobi, Senator Mutinda, I want to vacate my contribution earlier so that she can have an opportunity to speak. But I want to request her to allow me to speak so that I am stopped, Mr. Speaker, at exactly 25 minutes past. So could the clerks at the table stop me at 25 minutes past so that I allow Mutinda now to do her bit?
Honorable Senator, I have no problem with you spending less time than you're allocated.
Yeah.
But the procedure in the House is that after you speak, I have to give an opportunity to the other side. And I have Senator
So my gift I should give to Professor. I want to appeal to Tabitha I want to appeal to her to accept that, because we are very proud of Professor. Professor, the work you did in court, that was a study in the practice of law. The jibes you were throwing, my 2 young lawyers in my family, my daughter Vivian, and my son Sonista, they were very happy with you, the way you conducted yourself in court, and of course, you brought us the right result. Congratulations. Mr. Speaker, I want to speak to the problem of nominations. The nominations, as stated earlier by my colleagues, must cease being the decision of political party leaders. Members of political parties must vote to decide on the party list, so that after members of ODM have voted on all the names of the people who want to be nominated senators, then the women who get the highest number of votes are put on the party list in the order of the number of votes they got, so that it's not the decision of the political party leader. You can see the misguided contribution for the center of Nandi suggesting that party leaders conduct nominations from hotel rooms. I'm surprised that he was not forced to apologize and withdraw. We have distinguished senators here, people like Beatrice Oyoma, people with families, people like Mutinda with families. What message are we sending to their families that they were nominated from rooms? Shame on Senator Cherargei. He is even imputing further improper motive, Mr. Speaker, on senators who are males. Chemera, who are males. Is he suggesting that they are homosexuals? That their party leaders are homosexuals? It's unbelievable that we can degenerate to that level, Mr. Speaker. Mr. Speaker, I've said it before and I want to repeat that people living with disabilities, they should themselves vote amongst themselves to decide who amongst them should represent them and not the decision of political party leaders. I also believe that we should continue amending the laws until we ensure that women reps are elected not universally in the county, but they are elected by fellow women, because they are only women who know who are the best women that should represent them as women reps. If they don't want them to be women reps, then we should amend the constitution not to call them women rep. But because the constitution calls them women reps, they should be elected by the people they represent, the women, Mr. Speaker. Mr. Speaker, having said that, I now want to give way for our good professor to then inform us on his thoughts on this law I support.
Thank you, Senator. Senator Tom Ojienda.
Thank you, Mr. Speaker. Mr. Speaker, I will take a limited time in contributing to the amendments Elections Bill number 2 of 2024 that seeks to amend various provisions of the Elections Act. Mr. Speaker, I want to agree with the Senator Halwale on the timeless nature of this amendment and on the need to continually amend the Elections Act. Mr. Speaker, 2 points. Number 1, Mr. Speaker, tallying at polling stations has been the subject of various election petitions, and the time question that Mr. Senator Halwale has dealt with, signing or filling Form 34As, Bs and Cs, 35 and 37 for governors, 38 for senators, 39 for women reps, all those, Mr. Speaker, speak to timeframes that are necessary. Elections must and should be concluded at polling stations. The issue of nominations has been sticky, Mr. Speaker, with political parties and party leaders and perhaps technocrats having nominations for individuals from outside specific counties and constituencies. I'm glad, Mr. Speaker, that this bill seeks to rectify that anomaly. And if you are therefore not a registered voter in a particular area, you will therefore not be eligible for nominations. This question of importation, Mr. Speaker, must end. I allowed that amendment because it seeks to cure that anomaly. Mr. Speaker, I have litigated many election anomalies, and this bill is timeless because it comes to cure some of the problems that we have had within the process of conducting elections. Time delays and possibilities, Mr. Speaker, of rigging elections. I also, Mr. Speaker, must laud the time frame for registration of voters and the need for IBC to continue registering voters. However, Mr. Speaker, we must speak to the need of filling the slots that are available or that have not been filled for commissioners of IBC. Mr. Speaker, because of the continuous manner in which the IBC operates, the need for by-elections every other time, Mr. Speaker, there's need to urgently ensure that the IBC is fully constituted. And I hope, Mr. Speaker, that our principals and the players within the legislative sector and those who are responsible for ensuring that this process is concluded And those court cases are there, Mr. Speaker, should be concluded so that we have a fully operational IBC. I thank you, Mr. Speaker. I support.
Senator Tabitha Mutinda.
Thank you, Mr. Speaker, and thank you, my senior colleagues, for managing the time. I do appreciate. And Mr. Speaker, I start by saying that I do support this amendment bill. And looking at the clauses, especially the clause 19, which, Mr. Speaker, talks about the nomination slots, especially for the members of the county assembly. Mr. Speaker, looking at Senate, where I am specially elected, the Senate does recognize the specially elect through their delegations, and that is determined by where the voting was lastly taken, as in which county that you did vote. And that really applies very well in Senate. And it is important because then you are familiar with your area. For my case, my representation is Nairobi County, and when the bill clearly supports that a person to be nominated as a member of a county assembly should be a registered voter in that particular ward, Mr. Speaker, then yes, it is key, and it's something that I do support. It also gives the particular member of the county assembly serving in that that particular assembly to be able to maximally engage knowingly that the issues concerning that particular area or ward of representation are issues or matters of concern that he or she familiarizes with. We have cases in Nairobi County whereby people have, the members of the county assembly have been nominated from as far as parts of this country, but they are not really familiar with the concerns of Nairobi. They're not able to really understand. And you find that, as you know, most of them, us as members, we normally do mashinani, you know, we go to the ground over the weekends, but at times it becomes difficult because some of these members, they cannot go where they've come from because they don't resonate probably with those areas because they are now serving in a different area. But in the same area that they're serving, then there's little input because in both areas there's no synergy in any way. So it is important, and it is a very important amendment such that these people come from those particular areas that they have voted. It is very important. And you know very well, Mr. Speaker, even before voting, we do a lot of campaigns. And it is in those campaigns that we make manifestos, we give promises to the people. So it becomes easier when a member of county assembly then represents and is nominated from the fact that they vote from that particular area, he or she is in a better place to ensure those promises, the manifestos that they did promise during the campaign trail, they are able to focus on them and ensure that they deliver on the same, unlike when that happens in a different area. Mr. Speaker, the amendment on clause 20, that amendment of 38A, appointment of the polling stations, it is very key because also the voters need to, at an early time, familiarize with their voting polling stations. The 3 months duration, I find it even a bit less. It should be more.
Honourable Senators, it is now 6:30 p.m. It is time to adjourn the Senate. The Senate therefore stands adjourned until Thursday, 14th November 2024 at 2:30 p.m.